Hi everyone, welcome back. So in this session, we are gonna do a read out loud for um, private international law against us not. So we have 16 topics here, and we will start with the topic. The first one is introduction. So according to Cheshire, that part of the English law known as private international law comes into operation whenever the court is seized of a suit that contains a foreign element. Usually, the cases that come for trial before the municipal courts are those whose elements are internal. Occasionally, the courts are also seized of cases having foreign element. Whenever the court has to try a suit containing foreign element, the private international law or conflict of laws would come into operation. In a case, there is a foreign element if it has some contact with a foreign legal system. If one or the other element of the suit is connected with foreign country, there is a foreign element in that case. If the plaintiff or the defendant is a foreigner, there is a foreign element or a foreign complexion in the suit. For example, A, an Indian citizen, committed a tort against B, an Indian citizen in India. B filed a suit against A claiming compensation for tort committed by A. The suit is filed in an Indian court. In this case, there is no foreign element or foreign complexion. It is because the parties to the suit are Indians and the course of action for the suit has arisen in India. Now, another example. A, an Indian citizen, went to France and he had adulterous relation with B's wife. B was an Englishman. B filed a civil suit in England against A claiming compensation. In this case, before the English court, there is a foreign element since the defendant is a foreigner and the course of action for the suit has arisen in a foreign country. So, that is the effect of foreign element. Now, whenever a case containing foreign element comes before the English court, normally three questions arises. They are as follows. The first one, whether the court has jurisdiction to decide the case. The second, if the court has jurisdiction, which law is to be applied for deciding the case. And the third, if there is a foreign judgment on the disputed matter, whether the English court has to recognize it and enforce it. And why we are emphasizing on English court is that because our Indian law actually follows the private international law of England. That is why we are referring to English court, very similar to that of tort. Now, answers to all the above three questions are given by the private international law of England. Now, if the suit containing foreign element has arisen in an Indian court, the above stated three questions would normally arise. Answers to the above stated three questions would be given by private international law of India. The private international law of India is not much developed. The Indian courts would usually apply the principles of English private international law, though they are not bound to follow it. So, though we follow English private international law, we are not bound to follow it. The Indian courts are free to make necessary changes in the English principles to suit the Indian condition. The private international law of the country is not similar to that of another country. Each country has its own private international law. The private international law of a country is a part of the municipal law of that country. Private international law of a country is that part of municipal law which has got international perspective. So it is a part of municipal law which has got international perspective. Private international law is considered to be horizontal cross section of various civil laws of a given legal system. The main object of this law is to deal with the cases containing foreign element. Now, the next topic is that of successive stages of a case containing foreign element. So we already discussed what a foreign element is. Now, successive stages of a case containing foreign element. When a case containing foreign element comes before the English court, there will be four successive stages. They are A, that is jurisdiction of the English court. Then B, we have classification of cause of action. Then C, the selection of lex causae or the law that governs the matter. Now D, we have the application of lex causae. So the first step is determining the jurisdiction of the English court. Now, the first stage in a suit which involves the application of private international law is that the court should ascertain whether it has jurisdiction to try the case. The common law of England is that anyone in this world can approach the English court as a plaintiff, provided that he is not an enemy alien. Alien enemies cannot invoke the jurisdiction of English court. If a suit has been instituted by a foreigner in England and thereafter hostility begins between England and the foreign country to which he belongs, the English court will discontinue the proceeding instituted at the instance of enemy alien. And this can be well understood by the famous case law with respect to company law, that is Daimler and Company versus Continental Tire and Rubber Company. So what happened? This is a important landmark judgment with respect to lifting of corporate veil in company law. So what happened here was the company has its own distinct legal personality. So here in this case, the corporate veil was lifted, and why? The case, the all the members of the company was German citizens, and they had a English company registered, and there was a contract with the Englishman. Later, there was a default in payment, and the company wanted to company moved for a suit for recovery of money against the Englishman. And at that time, the war broke out. The World War. So during the World War, the England was having England and the Germans were in opposite sides. So behind the company, though the company was registered as English company, all the members, all its subscribers, everyone was Germans. So all the profit from the company was to Germans. So here the court applied lifting of corporate veil because it is a worse situation, and if the court was to execute the money recovery from Englishman and hand it over to the company, it will be like taking the money from our own subject and giving it to the enemy. So in this special scenario where the Germans are acting as the alien enemy, the corporate lifting of the corporate veil was applied, and uh, here they said they cannot invoke. The case was already going on. In such a case, when it is an alien enemy, they cannot invoke the jurisdiction of English court for their benefit, for the benefit of the alien enemy. So this is an important landmark judgment with respect to company law, and a good example for where for good example that the alien enemy cannot invoke the jurisdiction of English court. Now, a person may become amenable to the jurisdiction of the English court as a defendant if he is present in England and a process of court, that is writ or summons, is served upon him. Now, the English court can exercise jurisdiction against any person as a defendant who is present in England and a summons is served upon him. Thus, as per common law of England, presence of the defendant in England is the most essential fact for the exercising of jurisdiction. This strict adherence to this rule may sometimes do injustice. In order to mitigate such situation, the Common Law Procedure Act 1852 Common Law Procedure Act 1852 was enacted in England, and the English courts are conferred with the power to exercise jurisdiction against the defendant who are absent from England. So that the current scenario, the present situation is that the English courts can exercise jurisdiction against defendants who are absent from England, and this came by Common Law Procedure Act of 1852. When the English court exercised jurisdiction against absent defendant, that is called assumed jurisdiction. So what is assumed jurisdiction? When the English court exercised jurisdiction against absent defendant, it is called assumed jurisdiction. Under the following circumstances, the English court can exercise jurisdiction against absent defendants. That is, the assumed jurisdiction can be exercised in the following scenarios. The first one, if the subject matter of the dispute is land which is situated in England. So the subject matter should be land and it shall be situated in England. That is the first condition. And the second one, if the relief is sought against an English domiciled person, the English court will entertain the suit even though the defendant is not at present in England. So, what is the second scenario? That the relief is sought against a person of English domicile. The defendant is not present in England, but the defendant has a domicile in England. Now, the third scenario. If the action relates to administration of the estate of a person who died domiciled in England. So, the third situation is where the matter is relating to an immovable property or the estate, whatever is left by the deceased, and this deceased was domiciled in England. Now, the fourth one, if the action relates to trust property situated in England. So, the fourth one is when the action is related to trust property that is situated in England. And then the fifth one, in case of a contract, the English court will entertain a suit against absent defendant if the contract was concluded in England or the law to be applied to decide the case is English law. So, in most contracts, we can keep certain clauses such as arbitration clause and we have jurisdiction clause. So, a contract, there can be assumed jurisdiction over a contract if the contract was concluded in England. That is, both the parties agreed and signed to, and the contract came into being in England, or if there was a jurisdiction clause in that contract. Now, the next situation, that is the sixth situation, is that if the case is related to a tort. So earlier we said about contract, and the next, if the case is related to a tort, the English court will entertain a suit against absent defendant if the tort was committed in England. So here the assumed jurisdiction is based on the tort being committed in England. Now, the seventh one is if the plaintiff has sought an injunction against the defendant for restraining him from doing an act in England. So, what is the last scenario? That is, if the plaintiff has sought an injunction against the defendant for restraining him from doing an act in England. So, there is no offense committed, but it is an anticipation, and the plaintiff doesn't want the defendant to perform a particular act in England and thus moves to the court. Even in that scenario, there can be assumed jurisdiction for the English court. Now, when we discuss about jurisdiction, there is also immunity from jurisdiction. It is a well-established principle that an English court will not exercise jurisdiction over the person or the property of foreign sovereign state unless it is willing to submit to the jurisdiction. So, here what is the keyword? That is the foreign sovereign state. What jurisdiction over the person or the property of the foreign sovereign state. So, in that scenario, there is an immunity from jurisdiction, and that is not restriction but immunity. They can be brought under the jurisdiction if it is willing to submit to the jurisdiction. This rule of exemption involves two principles. So, what are the two principles? Let's see. One, the English court will not by issue of process make a foreign sovereign party to a case. So, English court will not by the issue of process make a foreign sovereign a party to a case. Then the next principle is that the English court will not by its process seize or detain a property which belongs to the foreign sovereign state. So what are the two principles? So the English court by its process won't will not do two things. What is it? Make a foreign sovereign a party to this case, or seize or detain a property which belongs to the foreign sovereign state. So the immunity is based on these two principles. Now, the immunity of sovereign state can be classified in two heads, and they are personal immunity as well as proprietary immunity. So, what is personal immunity? The personal immunity of the head of sovereign state is unlimited. The English court will not exercise jurisdiction against the head of the foreign state under any circumstance. So, personal immunity of the head of a foreign sovereign state is unlimited. The English court will not exercise jurisdiction against the head of the foreign sovereign state under any circumstance. That is only for to the head of the foreign sovereign state. Even if the sovereign comes under an assumed name and enters into commercial or ordinary transaction in the disguise of an ordinary private person, no action can be entertained against him if he objects to the jurisdiction. So we discussed earlier, this is immunity and not restriction. So this the persons or the people with immunity can be brought under the jurisdiction if they are willing to submit to the jurisdiction. So in immunity, we have personal immunity and proprietary immunity, and the personal immunity of the head of a foreign sovereign state is unlimited. And even if such a person comes in disguise of an ordinary person, even in that situation, they can exercise this personal immunity, that is unlimited personal immunity, unless he objects, he submits himself to the jurisdiction. Now, in Mikhail versus Sultan of Johor, that is Mikhail versus Sultan of Johor, that is in 1894, the English court held that the court will not exercise jurisdiction against the head of a foreign sovereign state even if he has acted under a false name. In this case, the Sultan of Johor fell in love with Mikhail and promised to marry her. He had acted as an ordinary citizen of Johor and represented to her a false name. He committed breach of contract to marry. Mikhail filed a suit claiming compensation for breach of marriage contract. The Sultan of Johor appeared in the court and claimed immunity. The English court granted immunity and held that appearance before the court only for the purpose of contesting the jurisdiction of the court cannot be treated as implied waiver of jurisdictional immunity. The head of the sovereign state can waive the immunity. In order to be valid waiver, it should be express and unequivocal. So, the Sultan came to the court to claim immunity. So, that doesn't mean that the Sultan is subjecting himself to the jurisdiction of the court. That was clearly stated in Mikhail versus Sultan of Johor. Further, what did the court say? How should the waiver of immunity be? That is, it should be, to be a valid waiver, it should be express and unequivocal. So this was given by the English court in Mikhail versus Sultan of Johor. Mikhail versus Sultan of Johor, and that is with respect to case law of personal immunity. Now we have proprietary immunity. The proprietary immunity of a foreign state can be studied under three heads. So the first one, if the sovereign is admittedly the owner of the subject matter of the suit. So what is the first situation? We are going to discuss about proprietary immunity. There are two types of immunity, personal immunity and proprietary immunity. Under proprietary immunity, we have three heads, and the first one, if the sovereign is admittedly the owner of the subject matter of the suit. Now, it is a well established principle that the English courts will not exercise its jurisdiction against the property of foreign sovereign state. So these are out of the two principles, this is one of it. And in the Parliament Belge, a case in 1880, Parliament Belge, a ship belonging to the Belgium government collided with a British ship in Dover harbour. The Belgian ship carried not only public mail but also merchandise and passengers for hire. An action brought against the Belgian ship for negligence was stayed on the ground that the ship was the property and proprietary of the foreign sovereign government. So, with respect to proprietary immunity, the first heading where the sovereign is admittedly the owner of the subject matter of the suit, we have the case law Parliament Belge, and here the suit for negligence was stayed on the ground that the ship was the property of the Belgium government, that is foreign sovereign government. And the next heading we have is, if the sovereign, though not the owner, is in de facto possession of the subject matter through its servant. So here the foreign sovereign is not the owner, but he is in de facto possession. And how is it this possession? It is through his servants, that is the foreign sovereign servants. Now, it is an established principle that the English court will not exercise its jurisdiction against a property which is in the de facto possession of a foreign sovereign. And here we have the case law in Christina. In the case law of Christina, the Republican government of Spain issued a decree requisitioning all private ships registered in Spain. The Christina, which is a private ship registered in Spain, was in British port of Cardiff at the time of the decree. The Spanish consul boarded the ship and dismissed all the crew members who were not sympathetic to new Republican government of Spain and appointed a new captain and crew on behalf of the new government. The owners of the ship filed a case in the English court to detain and get possession of the ship. The court held that since the foreign government possessed the ship through its servants, the English court has no jurisdiction. So that was the case law of the Christina, that is a private ship. And here the under proprietary head, first head, the proprietary immunity, the first heading was where the foreign sovereign government is the owner, and the second one, the foreign sovereign government is not the owner but the de facto possession holder through its servants. So the case of Christina is a perfect example of where the second heading was applied, that is the foreign sovereign government is in de facto possession though not the owner. Now the third head under proprietary immunity is that if the sovereign, though not in possession, has an immediate right to possession, the English court will not exercise jurisdiction with respect to a property over which a foreign government raise a claim over the disputed property. This principle was established by two decisions of the English court, that is the USA versus Bank of England and Rahimtullah versus Nizam of Hyderabad. So based on these two case laws, we have the third head, which is if the sovereign, though not in possession, has an immediate right to possession. Though under proprietary immunity we have three heads. The first is where the sovereign government is the owner, and the second one where the sovereign government has the possession, though not the owner, and the third one, the sovereign government has an immediate right to possession, though they don't have the possession at the moment. So here we have two case laws under the third head, and that is USA versus Bank of England and Rahimtullah versus Nizam of Hyderabad. USA versus Bank of England. During the Second World War, the German army seized some gold bars from a French company and carried them off to Germany. This was recovered by the Allies and deposited in the Bank of England to be shared among UK, France, and USA. The company claimed gold bars from the Bank of England. The court held that the sovereign governments were entitled to immediate possession of the gold bars, and hence the protective umbrella of sovereign immunity was available, and the action was dismissed. So, it was during the Second World War, and the German army seized the gold bars from the French company. So, the gold bars were initially that belonged to the French company, and that was seized by the German army. And later, this was recorded by the Allies and deposited in the Bank of England, and it was to be shared among UK, France, and USA. So currently, when it was deposited in Bank of England, who had the immediate right to possession? That was UK, France, and USA. And who claimed it? The French company, that is the initial owners of these gold bars, claimed it back. But what the court said was, at the moment, UK, France, and USA has immediate right of possession to these gold bars. So, though it was initially something that belonged to the French company, it cannot be returned to the French company because the immediate right of possession is vested with UK, France, and USA. So, the action was dismissed. And because UK, France, and USA, they are sovereign governments, and they have the protective umbrella of sovereign immunity, and that is the reason the action was dismissed. Now we have another case law here, that is Rahimtullah versus Nizam of Hyderabad. So Nizam is a sovereign here. In September 1948, when the Indian government was taking police action in Hyderabad, a sum of over £1 million was standing to the credit of the government of Nizam of Hyderabad with the Westminster Bank in London. The finance minister of Nizam, Mr. Moin, was authorized to draw on this account. Rahimtullah was Pakistan's High Commissioner at London. During the police action, Moin instructed the bank to transfer the money to Rahimtullah's account, and this was done by the bank. So, who is Mr. Moin? He is the finance minister of Nizam. And who is Rahimtullah? He was Pakistan's High Commissioner at London. And this issue is taking place in September of 1948. So, here during the police action, Moin instructed the bank to transfer the money to Rahimtullah's account, and this was done by the bank. As soon as the Nizam got information about this transaction, he gave notice to the bank and requested the bank to retransfer the amount in his name. The bank did not retransfer the money. Nizam instituted a suit in English court and made Rahimtullah, Moin, and the bank as the defendants. The bank was ready to pay the amount to the person having lawful title. The Pakistan government claimed immunity. The House of Lords held that the English court has no jurisdiction. According to Lord Denning, the claim was not recognizable by English court as the transaction was intergovernmental transaction to be resolved by intergovernmental negotiations. So what happened here? Mr. Moin was the finance minister of Nizam, and Rahimullah was the Pakistan's High Commissioner in London, and Moin instructed the bank to transfer the money to Rahimtullah's account, and it was transferred. And as soon as it was transferred, the Nizam got an information about this transaction, and Nizam requested to retransfer the money because this was not accepted or consented by the Nizam, but the bank denied it, and therefore he went to file a suit in the English court. But what did the English court say? This transaction is intergovernmental in nature, so the English court cannot take jurisdiction here, and it has to be dealt with intergovernmental negotiations. So that is with jurisdiction. So with respect to successive stages where of a suit containing foreign element, the first one was jurisdiction. We discussed about jurisdiction, the assumed jurisdiction, then the immunity. Under immunity we have personal immunity and proprietary immunity, and we have three heads under proprietary immunity. And now the next stage of a suit with foreign element is the classification of cause of action. So going into it, when a case containing foreign element comes before an English court for adjudication, the first stage is to ascertainment of jurisdiction. Once the court finds that it has jurisdiction, the next stage is classification of cause of action. In this stage, the court will find out the real character of the suit, and it will be put in the appropriate category. So, what are we doing here? We are going to find out the real character of the suit, and we are going to put it into appropriate legal category. And why a legal category is important? Because all the rules and provisions are classified, or they are put down in a categorical manner. So only if we classify a cause of action into the appropriate legal category, only then can we can find which is the relevant law or rules to be applied here. So this is a very important step. And we also have conflict of classification of cause of action here from time to time. That is the law of one state may classify it into one category and the law of another state into another category. So here we have conflict of classification of cause of action too, and it is to be determined which is to be accepted. Now going further, now in this stage the court will decide whether the cause of action relates to tort or contract or succession or matrimonial causes or guardianship of child, etc. Unless this classification is done, the judge will not be able to select the law to be applied to decide the case. In majority of cases, classification will be automatically done. In some cases, difficulties arise because a cause of action may equally be placed in one category or another. So that is where we have conflict of classification. Sometimes the cause of action may be classified by English law and foreign law into different categories. In this case, there arise what is called conflict of classification. As per the English law, the classification of the cause of action into different categories by foreign law need not be considered by English judge. A judge of the English court will only classify the cause of action by applying English law. So the classification will also be considered under a procedural law, you can say, and English law will accept only the procedural law of the forum. Now, in France, when a case containing foreign element comes before French court, the judge will classify the course of action by applying the foreign law. This principle was established by the famous Maltese marriage case 1889. Now, the plaintiff in this case was a widow. She filed a suit for share in her deceased husband's property before a French court. The landed property was situated in France. At the time of marriage, the husband and wife were domiciled at Malta. After the marriage, they settled down in France and acquired a French domicile. So, at the time of death, the husband was domiciled in France. This case involved foreign element as the husband and wife were domiciled in Malta at the time of their marriage. According to French law, when a widow claims a share in the deceased husband's property, it is the question of succession to land. According to Maltese law, the claim was one of matrimonial rights. So here there is a conflict whether to categorize it to a succession to land or as a case of matrimonial rights. The French court accepted the classification made by Maltese law. This type of classification will not be followed by English judge. So the case was brought before a French court and it accepted the classification by Maltese law. So this is not possible in English court. The English court will only accept the classification by the English law. So that is what we have to notice here. And this is the famous Maltese marriage case. And the next step with respect to this we have is the selection of lex causae. So that was with classification of course of action. And next we have selection of lex causae, that is the third stage. We have total of 4 stages in suits with foreign element, and the third stage is selection of lex causae. So in the third stage of a case containing foreign element, judge has to select the law to be applied for deciding the dispute. In order to select the lex causae, there is choice of law rule. The choice of law rule will depend upon something connecting factors that such as domicile, nationality, situation of property, place of celebration of marriage, etc. So what are we giving emphasis here? That is connecting factors. And just as we have conflict of classification, there is also conflict of connecting factors. What is important and considered as a connecting factor by the law of one state might not be a connecting factor and of the same relevance in the law of another state. So there is conflict of connecting factors too. Now, it is to be noted that even though the English private international law directs the judge to apply foreign law, for all purposes, foreign law will not be considered as relevant. It is well established that procedural matters will be governed by lex fori, that is, law of the forum or court. So, here what are we going to do once the classification is done? We are going to decide which law is to be applied in this subject matter or in this dispute under this classification. Even if the law that is going to applied is a foreign law, the English court will always follow the procedural law as lex fori. That is, the application of the lex causae or the foreign law will only be the substantial law, and the procedural law will always be lex fori, and that will be discussed in detail in the next stage. Now, this principle was established by the decision in Ogden versus Ogden. So what is the case law here? Ogden versus Ogden. OGDEN. Ogden versus Ogden. In this case, a 19 years old man, and he was domiciled in France married an English domiciled woman. So, by the French law, this a 19-year-old man to get married shall get the parental consent, but he married without the parental consent. And later, this English woman married another Englishman, and that Englishman brought a suit before the English court saying that his marriage is void as she was married when the Englishman married the English woman. So, what the court had to look into here was whether the marriage between uh, the Frenchman when he was 19 years old and the English woman was it valid, because by French law a 19-year-old man cannot get married without the consent of the parents. If he has to marry without consent, he should have attained a minimum of 25 years of age. So here the English court considered. Uh, what did the Englishman move the suit to? It was a suit for nullity of marriage. The English court held the judgment of the French court was based on the principle that husband has not obtained consent of parents. According to English judge, obtaining consent of the parent is only a procedural matter, and procedural matters will be governed by lex fori, that is the English law. As per the English law, for violation of a procedural rule, a marriage cannot be declared null and void. Thus, English judge has not recognized the French judgment. That is, a French judgment is that this marriage between the French man and English woman is null and void, but the English judge did not recognize the French judgment and held the marriage with the French man is still subsisting. The court declared the second marriage, that is, the English woman marrying the English man, the second marriage as null and void. So that is with Ogden versus Ogden. Now, the last stage of a suit is suit with foreign element is the application of lex causa, and we have doctrine of renvoi here. So the last and final stage of a case containing foreign element is the application of lex causa. This would appear to be simple thing to do, but in fact it is far from simple. The foreign law has to be proved by expert testimony. The experts and the textbooks may give conflicting views regarding the actual state of foreign law. Apart from this, the application of lex causa brings about the doctrine of renvoi. Renvoi arises because of the different interpretations that can be given to the lex causa or selected law. Now, renvoi may be single renvoi or double renvoi. The doctrine of single renvoi is followed in France and some other continental countries. In England, the doctrine of double renvoi is being followed. Now, single renvoi. Single renvoi is otherwise known as simple renvoi or partial renvoi. The word renvoi means remission or reference back. The doctrine of single renvoi is explained by following illustration. Now, X is a Bavarian national domiciled in France. He died intestate in France, leaving movable properties in France. The legal heirs of X filed a suit in France for sharing the movable properties of X. Now, this case has foreign element because X was a subject of Bavaria at the time of his death. Thus, the private international of France has to be applied. Now, okay, here why there's a foreign element? The X was a Bavarian national, but he was domiciled in France, and the suit is regarding the immovable properties. And where is the immovable properties? These immovable properties are in France. So In general, immovable properties by the French law, lex situs is applied. By Bavarian law, lex domicilia is applied. Whereas domicile of the deceased, that is France. So let's see what happened. Now, the Private International of France says that the law to be applied for dividing the immovable properties of a person who died intestate is the law of the nationality, that is, lex patriae. The law of the nationality of the deceased is Bavarian law. The French judge has taken the Bavarian law in the widest sense and considered the private international law of Bavaria. So it was the French judge who is considering the private international law of Bavaria. The Bavarian private international law says that the law to be applied for dividing the immovable properties of a person died intestate is the law of domicilia at the time of the death. Thus, the Bavarian law refers the matter back to the French law. So, once again, X is a Bavarian national but domiciled in France. He died intestate. He left immobile properties in France. So the legal heirs wanted this immobile property and moved a suit for the division of the immobile property. In the French court, the land was in France, so they moved the suit to French court. Now, the first step, the French judge applied the French international law. And what does the French international law? It says that you have to refer to the law of the nationality or lex patriae. Lex patriae, that is law of nationality. And what is a nationality here? He was a Bavarian national. So the Bavarian international law was referred to by the French judge. That is by the Forum Court. The Forum Court itself referred the Bavarian international law. And by the Bavarian international law, it said that refer to lex domicilia. And this person was, at the time of death, he was domiciled in France. So, the Bavarian law referred back to the French law. So, then the first step, the French international law was applied. In the second step, the Bavarian international law was applied and it was again referred back to the French law. So, when it comes back, the municipal law of the French law, not the French international law, the French law will be applied but not in the widest sense. So, the law can be applied in the narrow sense and the widest sense. Now, the French judge, when accepts this reference back and applies the French international law dealing with the succession to immobile property, there is single renvoi or simple renvoi or partial renvoi. So here only two states are involved. The first state applies its international law and refers to the international law of state B. The state B applies the international law of state B and applies referred back to the state A. But there is no physical transfer of cases. The forum state is applying the French law by staying in the court. That is, they don't physically transfer the case. That is an imaginary travel to the other state. Now, the next one we have another case, that is Fargo's case. Here, it is similar to what the illustration we discussed right now. Fargo was a Bavarian subject domiciled in France. He died intestate in France, leaving immobile properties in France. The legal heirs of Fargo filed a suit in France for sharing of immobile properties of Fargo. So this is the same as we explained in the illustration. That is the Fargo's case. So, and that is simple renvoi. The French international law was applied, then the Bavarian international law was applied. It was referred back to the French law and the French law was applied. French law was applied. When it was referred back, the French law was applied without considering that there is a foreign element. It was considered in an ordinary sense. Now we have that was simple renvoi. Now we have renvoi by transmission and remission. So simple renvoi may arise by two methods. There are renvoi by remission or renvoi by transmission. In the case of renvoi by remission, the private international law of a country will direct the judge to apply another country's law, and that other country's law will refer back to its first country. That is similar to the example illustration we saw just now. That is example, country A's private international law directs the judge to country B, and the law of country B referred it back to country A. In this case of renvoi, so that is renvoi by transmission. In this case of renvoi by transmission of a country's law will transfer the judge to another country, and the other country's law will refer the judge to yet another country. So if it is referring back to the same country, that is remission. Now in a case there is a third state involved, and the second country's international law is referring to the law of the third state, then that is renvoi by transmission. That is, in renvoi by transmission, a country's law will refer the judge to another country, and that other country's law will refer the judge to yet another country. So with an example we can understand that the private international law of country A refers the judge to country B, and the law of the country B refers to country C. So that is renvoi by transmission. Now the next we have double renvoi. So renvoi by remission and renvoi by transmission both are under simple renvoi, and then we have double renvoi or the foreign court theory. Double renvoi is also known as foreign court theory. The double renvoi is otherwise known as total renvoi or English doctrine of renvoi. So double renvoi is accepted only by English courts. That is why it is also known as English doctrine of renvoi. According to this theory, the English judge has to make an imaginary journey to the foreign land and apply whatever law the foreign court would have applied had the foreign court seized of this case. So in simple renvoi, the English court applies it's on the forum states international law first, and by that international law it is referred to the international law of another country. But in this case, what happens in case of double renvoi, before applying the international of the forum state, the judge makes an imaginary travel to the other country and applies the international law of that state, very similar to how that court would have moved this case if the case was given there in that state. So that is why it is a double renvoi. Now example, X, a British subject domiciled in Belgium, he dies interstate in Belgium, leaving some immovable property in England. The legal heirs of X filed a suit claiming share of immovable property. The suit is filed in England. As per the English law, succession to immovable properties is governed by the law of domicile at the time of death of the owner of the property. Thus, the law to be applied is Belgium law. But according to double renvoi system, the English judge has to make an imaginary journey to Belgium and should imagine that he is a judge in the Belgian court dealing with this case. If the case was filed in Belgium, the Belgian private international law had to be applied. According to Belgian private international law, the succession to immovable property is to be governed by the law of nationality. The Belgium law does not recognize renvoi system. So the Belgium judge would have applied internal law of England dealing with the succession to immovable properties. The English judge in such a situation should apply English law for dividing the property. So that is with double renvoy. And the important case laws we have here is re Annesley and re Rose. Re Annesley is one of the important case. Re Annesley as well as re Rose. So what happened in re Annesley? That is a 1926 case. Annesley executed a will and died domiciled in France. She was a British subject at the time of her death. The will she executed was valid according to the English law, but it was invalid according to the French law. The question before the English court was whether the will was valid or not. The English judge applied the doctrine of double renvoy and held that the will was invalid. The English judge has come to its conclusion by making an imaginary journey to France and decided the case as if it was decided by the French judge. If the case was before the French judge, he would have applied French private international law. The French private international law says that the law to be applied decided the validity of the will is a law of nationality, that is lex patriae, and English law, that is the English law. The French system follows simple renvoy, so the French judge would have considered English private international law. The English private international law says that the law to be applied is law of domicile, that is lex domicilia. This reference backed by the English law would have been accepted and applied by the French judge. Similarly, the English judge applied the French law and decided that the will was invalid. Now there is re Rose. Here also it's a similar case. Here Janet Ann Rose was a British subject and she was domiciled in Italy. She died in Italy, leaving some immovable properties in England as well as in Italy. She had a son. Now she executed a will, but nothing was given to her only son. According to the Italian law, son is entitled to a portion of the property as per law, and the will is invalid, so no property was provided to him. But according to the English law, the will is valid even though no property is provided to him. Now, according to the English private international law, the law to be applied to decide the validity of the will is the law of domicile of the testator, lex domicilia. According to the Italian law, the validity of the will is to be decided by the law of nationality or lex patriae. The English judge applied the doctrine of double renvoy and held that the will was valid. The decision was arrived at by the English judge since Italy does not follow single renvoy or double renvoy system. If the case was filed before an Italian judge, he would have applied English law and declared the will as valid. So that is with re Rose. Now, this double renvoy, which is also known as the foreign court theory. Why is it called the foreign court theory? That is because before applying the foreign state's private international law, the judge makes an imaginary route to the destination state or the foreign state and applies the foreign international law first. Only then, by the foreign international law, if it is referred back, the foreign state international law is applied. Now, drawbacks of foreign court theory. The first one is foreign court theory does not ensure uniform result. And the second one, if both the countries recognize foreign court theory, there will be an international reference forth and back. It will be a never-ending loop. So what Cheshire calls international, that is why Cheshire calls it a international game of lawn tennis, because it will be continuing forth and back. Now the third one, the foreign court theory is difficult to apply because the English judge will not be able to ascertain what should be done by the foreign judge. So these are the drawbacks of foreign court theory. Now, While we are discussing about foreign court theory, we said about foreign law, and the judge would make a imaginary route to the destination state and apply the foreign law. So we have to consider the proof of foreign law, or how to prove foreign law. That is very important here. So that is topic 3 here, proof of foreign law or how to prove foreign law. When a case containing foreign element comes before the court, the private international law of England may direct the judge to apply foreign law. Points of relevant foreign law should be proved by the parties. So it is the burden of the parties to prove it. They are treated as question of fact. They should be proved to satisfaction of the judge as the any other fact. The onus lies on the party who wishes to rely on foreign law. The party must state in his pleadings and also prove it at the trial by adducing evidences. If he does not do so, the court will decide the case as it were a purely domestic case. So, what happens if the foreign law is not proved? The court will treat it as a case which was purely domestic case. Now, this principle is subject to an exception by virtue of the British Law Ascertainment Act of 1852. By which law? British Law Ascertainment Act of 1859. Earlier we discussed about Law Procedures Act of 1852, that is with respect to Common Law Procedures Act of 1852. That is when we discussed under assumed jurisdiction. When English court started entertaining assumed jurisdiction, that is after Common Law Procedure Act of 1852. And here we are discussing about the exception where the foreign law in general, when the foreign law is not proved, uh, it is determined, the case is determined as an ordinary domestic case, and there is an exception to this, and this general rule, exception to the general rule is by the British Law Ascertainment Act of 1859. If the foreign law involved is the law of some British territory, the court has power to ascertain that law and apply it even if there is no pleading. So what does this act enables? So if the foreign law involved is the law of some British territory, the court has power to ascertain that law and apply it even if there was no pleading on it. The foreign law must be proved by expert evidence. It cannot be proved by simply placing the text of the foreign law or by citing foreign decisions or foreign textbooks. Foreign law can be proved only by examining the experts in the foreign law. And here there is a conflict. The statements by the experts and what is given in the textbooks might be different. And another conflict that comes here is what one state considers as a substantial law may be considered as a procedural law by the other state. So there is a conflict between interpretation of the law as to whether it is procedural law or whether it is substantial law. Now the expert witness will be cross-examined in the court. In order to prove foreign law, the opinion of the expert is relevant. The following persons are considered to be experts in the foreign law. That is, 1. Any person who is practicing as a lawyer in a particular legal system. And second, a person who follows a calling by virtue of which he must have acquired a practical working knowledge of foreign law. So with the second category, that is persons who follow by calling by virtue of which he must be acquired a practical working knowledge of foreign law. With respect to this, it was held that not only a foreign judge or a legal practitioner would be a competent witness, but also such persons as an ambassador and embassy official, a reader in law, a Roman Catholic bishop, etc., have been held to be competent. Now, in a case that is Prakasho versus Singh, that is a 1968 case. Here, reversing an erroneous decision given by the trial court on the point of foreign law, it was stated, although foreign law is a question of fact, it is question of fact of peculiar kind. So that was held in Prakasho versus Singh. So there are some situations where there is a exclusion of foreign law. So circumstances may arise under which a foreign law which is normally applicable should be excluded and instead the lex fori should be applied. This is done in the interest of public welfare or due to some other overriding considerations. Now, for instance, there is the continental doctrine of order public, under which any domestic rule designed to protect domestic welfare must prevail over any inconsistent foreign rule. Under English private law, those foreign laws which are of penal or revenue nature or which are inconsistent with the fundamental policy of English law are excluded. So, in a case that is Holman versus Johnson, Lord Mansfield stated, no country ever takes notice of the revenue laws of another. Since then, it was assumed that the English courts will not enforce foreign revenue laws. But there was a question that this principle of Lord Mansfield, is it applicable in the modern scenario? So this was made clear by India versus Taylor, that is a 1955 case. So the facts of the case is that Government of India claimed from liquidator in England a large sum of money due as capital gains tax under the following circumstances. That is, the Delhi Electric and Tracting Company Limited was a company incorporated in England but carrying on business in India. In 1947, the company sold its business to Government of India. The sale price was company in India and the amount was remitted to England after a few days. 2 years after this, the company went into voluntary liquidation in England and Taylor was appointed as the liquidator in the liquidation process. So, this company had business in India but was incorporated in England and it was sold to Government of India. The prize money was remitted to England and 2 years after this the company in England is going into liquidation and Taylor is the officer in charge of it. He's the appointed liquidator in the liquidation proceeding. Now the Indian Commissioner of Income Tax claimed about 11.5 lakh rupees to the liquidator, but the liquidator rejected this claim and the case finally came to the House of Lords. For the government of contended that the rule of exclusion of foreign laws applied only to penal laws and Lord Mansfield was wrong extending revenue laws. Further, whatever may have been in the past, there is necessity for modification in the case belonging to Commonwealth, particularly in the case of taxes similar to those imposed in England. These arguments were not accepted by the House of Lords. It was unanimously, without any objection, it was unanimously held that English courts will not enforce the revenue laws of another country. So, English courts will not enforce foreign revenue laws, whether the enforcement is direct or indirect. So, they cannot enforce this directly or through indirect methods. So, under the English private international law, those foreign laws which are of penal or revenue nature or which are inconsistent with the fundamental policy of English law are excluded. So, foreign penal laws. It is a well established principle that the English court will not enforce foreign penal laws. A criminal law of a foreign country imposing penalty will not be directly or indirectly enforced by the English court. That we have two case laws here. The first one is Huntington versus Attrell. 1893 Huntington versus Attrill. The Privy Council affirmed the principle that foreign penal laws are not enforceable by the English courts. The question whether the foreign law is penal or not will be decided by the English court. Now, another case law is Benco de Vizcaya versus Don Alfonso. That is BENCO, Benco, DE, and Vizcaya, VIZCAYA, Benco de Vizcaya versus Don Alfonso. That is a 1935 case. Here, the King of Spain deposited certain securities with the Westminster Bank in London. The king was expelled, and the new Spanish Republican government decreed that all his properties, wherever situated, should be confiscated for the benefit of the Spanish state. In pursuance of this decree, an action was brought in the English court by a nominee of the state to recover the securities from the bank. The court dismissed the suit, holding that the Spanish decree was of penal in character. Now, the next one is foreign revenue laws. So, English courts will not enforce foreign revenue laws, may it be directly or indirectly. This principle was well established in the decision of the House of Lords in Government of India versus Taylor 1955. So we already discussed this case. So foreign revenue laws will not be enforced by English court, may it be direct or indirect. Then we have foreign laws that is repugnant to the public policy of England. The English court will not enforce or recognize any right arising under a foreign law if such enforcement or recognition would be inconsistent with the fundamental or distinctive policy of English law. According to Scarman Justice, an English court will refuse to apply a law which outrages its sense of justice and decency. The foreign law which violates the English concept of morality will not be enforced by the English court. A foreign law which would affect the good relation of England with foreign countries would not be enforced by the English court. Now, here we have some instances, that is A. When the fundamental conception of English justice are discarded. So we are listing down the circumstances where foreign laws repugnant to public policy of England will be excluded. The first scenario, when fundamental conceptions of English justice are discarded. For example, violation of the principles of natural justice, in that no opportunity was given to the other party to present his case. So that is one scenario. And the second one, when English conceptions of morality are infringed. So the first one was the fundamental conceptions of English justice was discarded, and the second scenario, when English conceptions of morality are infringed. Example, a contract or some other transaction which promotes sexual immorality, a contract to pay money to a prostitute as the price of prostitution. These will be excluded. Now, the third scenario or the third circumstance, when the interests of United Kingdom or its good relations with the foreign powers are affected. That is the international relations of the UK with other countries. For example, a contract to pay money for revolutionary activity in a friendly country, or a contract to import liquor in violation of the prohibition laws of friendly foreign country, or a contract to export prohibited commodity, etc. Now, the fourth scenario is when the foreign law or statute offends against English conception of human liberty and freedom of action. For example, slavery, bonded labor, excommunication, the disabilities imposed by Nazi Germany on Jews, discriminatory laws against colored people, etc. The paralyzing restrictions on freedom imposed by despotic governments will not be recognized by English courts. So, we have enlisted four situations. The first one, when it is violative of the fundamental conceptions of English justice. The second one, when it infringes the English conception of morality. The third one, when the interest of United Kingdom and the international relations with other countries is affected. And the third one, when the foreign law or statute offends English conception of human liberty and freedom of action. So that is the paralyzing restrictions on freedom imposed by the despotic governments will not be recognized by the English court. Now, with respect to the status conferred by the foreign law, the general principle is that the status of a person is governed by lex domicile, but English law will not give effect to the result or incidents attributed to this status if the foreign lex domicile offends against the fundamental conception of freedom and liberty or some other well established canons of English public policy. So that is with foreign laws and the recognition of foreign laws, the proof as well as the recognition of the foreign laws. The next topic we have is domicile, and it is one of the with respect to private international law, it's very important and it is a bit wide topic. So, domicile refers to a person's civil status, and nationality refers to a person's political status. So, there is domicile and nationality. Domicile is not the same as nationality. Domicile refers to the civil status, and nationality refers to the political status. Under the English private international law, for deciding certain disputes, law of domicile of the parties is to be applied. So throughout various examples earlier, we did discuss about lex domicilia. So that is the law of domicile, mostly with respect to the succession or succession of immovable properties. Most of the nations apply lex domicilia, and there we discussed domicile. So it is very important to understand what is domicile and what is nationality. What is the difference and what is the importance of domicile? The word domicile refers to a person's permanent home. In Vicar versus Hume, that is 1858 case, it was held that a person's domicile means the place where he has his permanent home. According to Lord Cranworth, by domicile we mean the permanent home, and if you do not understand your permanent home, I am afraid that no illustrations drawn from the foreign writers will be very much help you to it. And these are the words of Lord Cranworth. Once more, by domicile we mean the permanent home, and if you do not understand your permanent home, I am afraid that no illustrations drawn from foreign writers will very much help you to it. These are the words of Lord Cranworth. And in Union of India versus Dudnath Prasad, that is a 2000 case, Union of India versus Dudnath Prasad, the Supreme Court observed as follows, that is, etymologically, residence and domicile carry the same meaning, in as much as both refer to the permanent home, that is, residence and domicile. But under private international law, domicile carries a little different sense and exhibit many facets. Domicile may take many colors. It may be the domicile of origin, domicile of choice, domicile of dependence. So it can be either of it. Domicile plays an important role in the conflict of laws. So the significance of domicile was clearly explained and detailed by the Supreme Court in Union of India versus Dudnath Prasad 2000 case, Once again, Union of India versus Durnath Prasad. Here, Supreme Court observed as etymologically, residence and domicile carry the same meaning in as much as both refer to the permanent home. But under private international law, domicile carries a little different sense and exhibits many facets. Domicile may take many colors. Each may be the domicile of origin, domicile of choice, domicile of dependence, either of it. Domicile plays an important role in the conflict of laws. That is in Union of India versus Durnath Prasad. The English law classifies domicile into three categories. They are the following, that is, domicile of origin, domicile of choice, domicile of dependence. Domicile of origin. According to English law, a person should have a domicile from birth till death. A person's domicile of origin is that which the law attributes to a child when it is born. It is the domicile which is communicated to a person by operation of law at the time when the person is born. In the case of legitimate child, the domicile of origin is the domicile of the father, provided that the child should be born during the lifetime of the father. So, in case of a legitimate child, the domicile of origin is the domicile of father. And what is the condition? The child should be born during the lifetime of the father. If the child is born after the death of the father, the domicile of origin of that child will be mother's domicile. In the case of illegitimate child, the domicile of origin is domicile of the mother at the time of the birth. In case of a foundling, the domicile will be the country where the child was found. So, domicile of origin we discussed in four aspects: a legitimate child born during the life of the father, legitimate child born after the death of the father, illegitimate child, and a foundling. So, legitimate child born during the life of the father, the domicile will be that of the father. Legitimate child born after the father's death, the domicile will be the mother's domicile at the time of the birth. An illegitimate child, the domicile will be the domicile of the mother at the time of the birth. With respect to a foundling, the domicile will be the country where the child was found. Now we have domicile by choice. Domicile of choice is that domicile which a person voluntarily acquires. So it is a choice. The person is acquiring it voluntarily. So domicile of choice is that domicile which a person voluntarily acquires by his acts. If a person who has attained majority and is of sound mind goes into a country which is not his domicile of origin and settle in that country with the intention to reside permanently, he will acquire domicile of choice of that country. So what is happening? The person is going to that country and settling there with the intention. The intention is significant here, with the intention to reside permanently. Then he will acquire domicile of choice of that country. Now, according to English law, a person can acquire domicile of choice only when three conditions are satisfied. What are these three conditions? 1. He should have attained majority and be of sound mind. So he should be major and of sound mind. 2. He should reside in that country. There should be residence. He should reside in that country. And third, his intention should be to reside in that country permanently. There should be intention to reside in that country permanently. So these are the three conditions. 1. He should be major and of sound mind. 2. He should reside in the country. And 3. He should have the intention to reside in the country permanently. So these three conditions should be satisfied to acquire domicile by English law. Not it is by English law. Now, Winans versus AG, that is a 1904 case. Winans versus AG, that is Winans. Winans versus AG. Now, Winans' domicile of origin was Maryland in USA. He was born in USA. Till the age of 26, he was engaged in his father's business in USA. Then he left USA for Russia, and for about 10 years he was employed by the Russian government in building warships to be used against England. He then became afflicted with tuberculosis. The doctors advised him to reside in Brighton, a place which is the most suitable for patients suffering from tuberculosis in England. That is Brighton in England. He first rented rooms in Brighton. Later, he took on lease 2 houses in Brighton. Till his death, after a period of about 38 years, he resided in England. He used to visit Russia and Germany every year. He never visited USA after he left in his youth. He died in England, leaving a huge fortune. The English court had to divide his properties. According to the English law, the movable properties of a person who died intestate are to be divided according to the law of domicile or lex domicilia at the time of his death. So that is the English law, and he was in England for 38 years. The English court had to decide the question, what was the domicile of Winan at the time of his death? The court held that Winan had not acquired English domicile of choice even though he resided in England for a long period. It was also held he had no intention to treat England as his permanent home. The English court came to this decision by examining his activities during his lifetime. Moreover, Winan's illness compelled him to settle in England. His residence in England was not voluntary. He was not afflicted by tuberculosis, he would not have touched his foot in England. So, the English court said that he did not acquire domicile by choice of England. He did not acquire English domicile by choice. So, the English court denied this domicile by choice. That is Winans versus AG. Though he was in resident in England for 38 years, he did not have any intention to settle there permanently, and it was not voluntary. His residence was not voluntary. He was compelled by his disease, that is tuberculosis. Now, another case law, that is Ramsay versus Liverpool Royal Infirmary. Ramsay versus Liverpool Royal Infirmary, 1930. One George Bowie, who died in England, left a will. So George Bowie, he died in England and he left a will. The will was invalid according to the English law, but the will was valid according to the Scottish law. According to the English private international law, the validity of will is to be decided by applying law of domicile, that is lex domicilia. Thus, the question before the English court was that what was the domicile of George Bowie at the time of his death? George Bowie was born in Scotland. His domicile of origin was Scotland. He was working in Scotland till the age of 37. He then moved to England, and until his death he resided in England. He did not work in England. He lived on the bounty of his brother. During a period of 36 years stay in England, he left England only twice. Once on a short visit to USA and once on a short trip to the Isle of Man. He never returned to Scotland, not even to attend his mother's funeral. He even made arrangements for the burial of his body after his death in England. There was no evidence to show that he had intention to return to Scotland. Nevertheless, House of Lords held that he had not acquired English domicile by choice. It was held that long residence alone is not sufficient to acquire domicile of choice. A person who has not accepted an employment and lived only on the bounty of another for a long period in a country cannot claim to have acquired English domicile by choice. So here he did stay in England for such a long time. He never returned to Scotland, or he only made two short visits outside the country or is there. But he was living on the bounty of his brother and he never found an employment to sustain him in England forever. So if his brother was not providing his expense, he might not have been in England. So long residence without employment, and even though he did not live outside the country in longer period, it was not sufficient for the acquirement of domicile of choice. And domicile of origin always subsists until a domicile of choice or domicile of dependence is acquired. So domicile of origin does not go until another domicile is acquired. So another case law we have here is Shankaran Govindan versus Lakshmi Bharati. That is 1964. Shankaran Govindan versus Lakshmi Bharati, 1964. Here, one Dr. Krishnan, belonging to an Irava family in Travancore, left for England in 1920 for higher studies in medicine. He resided in England uninterruptedly for 30 years till his death. After completing his studies, he practiced in England. He purchased a building in England. He had some properties in India. During his stay in England, he never came to India. However, he wrote letters to his relatives in Travancore stating that he would come back to India. He was unmarried and died intestate in England. The Kerala High Court had to decide the question: what was his domicile at the time of his death? The Kerala High Court held that he has not acquired English domicile of choice since he had the idea to come back to India. On appeal to the Supreme Court, the decision of the High Court was reversed and held that he has acquired the English domicile of choice. According to the Supreme Court, the letters written by him were only to threaten his elder brother, and he had no real intention to come back to India. It is not residence per se, but residence accompanied by certain intention that constitute domicile. So this is very important. It is not residence per se, but residence accompanied by certain intention that constitute domicile. A man's residence in a country is prima facie evidence to show that he is domiciled in that country. But residence, however long, cannot be the sole test to determine the acquisition of domicile. Long residence does not constitute a brief residence, does not negate a domicile. Everything would depend upon the attendant circumstances. If a person has clear intention, he may acquire domicile of choice even though he has resided in the country only for a short period. An Englishman with the intention emigrating to Australia winds up all his affairs in England and sets sail with his family to Australia. After residing for a short period in Australia, he dies. He can be regarded as domiciled in Australia at the time of his death because his intention to change domicile is very clear. So it is not residence per se, but residence accompanied by certain intention that constitute domicile. Now the third type of domicile is domicile of dependence, that is domicile of dependent persons. According to English law, there are three classes of dependent persons for the purpose of domicile, that is infants, lunatics, and married women. So, after passing the Domicile and Matrimonial Proceedings Act of 1973, which is it? Domicile and Matrimonial Proceedings Act of 1973, the dependent status of the married woman has been given up in England. So, these categories are the infant, lunatic, and married women. After passing Domicile and Matrimonial Proceedings Act of 1973, the dependent status of married women has been given up in England. Now, domicile of infants. A child acquires at birth a domicile of origin by operation of law. This will be the domicile of his father if born during the father's lifetime and the child is legitimate. If the child is illegitimate or born after the father's death, the child gets the domicile of his mother. A foundling gets the domicile of the origin of the country where it is found. During the minority of child, it is incapable of acquiring a domicile of choice. He will be having the domicile of the person on whom it is legally dependent. This is the domicile of dependence. If the father of a minor changes his domicile, the new domicile is automatically communicated to the minor. This new domicile is the domicile of dependence. The domicile of origin is unaffected by the changes occurring in the parent's domicile during the minority of the child. Now, so once again, if the parent changes the domicile of dependence of the child changes. However, the domicile of origin is unaffected by the changes occurring in the parent's domicile during the minority of the child. That is an important point here. Now, we have domicile of lunatics. As in the case of any child, an insane child or insane person also get domicile of origin by birth. During minority, if the father changes his domicile, the domicile of minor insane will also change with the father's domicile. If a person becomes lunatic after attaining majority and after acquiring a domicile of choice, he retains this domicile during the period of lunacy. Not if a person becomes insane after attaining majority and after acquiring a domicile of choice, he retains this domicile during the period of lunacy. Then comes domicile of married women. Under the English common law, the domicile of a married woman was the same as the domicile of her husband. On marriage, the domicile of her husband was automatically communicated to the wife. As and when the domicile of the husband changes, the wife's domicile was also changed. This rule has now been abolished in England by the Domicile and Matrimonial Proceedings Act 1973. By virtue of the provisions of this act, the married woman retains her domicile and is capable of acquiring a fresh domicile independent of that of her husband during the subsistence of marriage. So that is with domicile of married women. Now, to constitute domicile, the residence of course must be voluntary, a matter of free choice and not compulsion. So what does this actually mean? So as we discussed, there are three types of domicile under the English law. That is domicile of origin, domicile of choice and domicile of dependence. In order to acquire domicile of choice, mere residence in a country is not sufficient. Even though a person resides in a country for a long period, he may not acquire domicile of that country unless he resides in that country voluntarily and with certain intention to take it as a permanent home. In the case of the following persons, residence in a foreign country is not voluntary and they do not acquire domicile of choice. Who are these persons? So that is prisoners, refugees, fugitives from justice, fugitive debtors, and invalids. So these persons, no matter how long they stay in a country, they don't acquire domicile by choice. That is prisoners, refugees, fugitives from justice, then fugitive debtors and invalids. So, prisoners. In the case of prisoners, as a general rule, they cannot acquire domicile of choice of the country where they are imprisoned. Now, refugees. In the case of refugees who flee the country of their origin out of the necessity circumstance, the domicile may not change. It is because they may have a hope in their mind to return to the country of origin when it becomes safe for them to do so. Now, the third one is fugitives from justice. In the case of fugitives from justice, their residence in a country cannot be said to be voluntary. They escaped from the country of origin in order to avoid evil consequence of crime. They may have an idea of returning to the country of origin and thus they would not acquire fresh domicile of choice. Then there is fugitive debtors. A debtor who was compelled to run away from his domicile of origin to avoid creditors may not acquire domicile of choice of the country where he is at present. Now there are invalids. In case of invalids who settle in a foreign country for the sake of their health, the domicile of choice cannot be acquired. And this we have already discussed in Winans versus AG, where he had to reside in England, Brighton, England, just because of his illness, that is tuberculosis. That was discussed in Winans versus AG. Now, difference between domicile of origin and domicile of choice. The first point, domicile of origin is communicated to a person by birth. Domicile of choice is that which a person acquires by his voluntary act. So, one is by birth and one is by voluntary act. The second point, the domicile of origin is much more enduring and less easily shaken off when comparing with the domicile of choice. We already discussed earlier the domicile of origin continues to exist until a new domicile is acquired. So it is not easily shaken off. It is more enduring. A very strong evidence is required to displace a domicile of origin by domicile of choice. Domicile of choice can be relinquished easily. The third point, the domicile of choice will be lost forever when a person leaves the country of domicile of choice with animo non revertendi, that is, with intention not to return. Animo non revertendi, that is, with intention not to return. So, the domicile of choice will be lost forever when a person leaves the country of domicile of choice with animo non revertendi, with an intention not to return. The domicile of origin will not be lost forever even though a person leaves the country of domicile of origin with animo non revertendi until he acquires a new domicile of choice. The domicile of origin continues to be in operation, and when he acquires a new domicile of choice, the domicile of origin will be kept in abeyance and it will be in a morbid condition. So it is not taken away, it is kept in abeyance. Domicile of origin is kept in abeyance and in a morbid condition when a new domicile is acquired. Now the fourth point, the domicile of origin is subject to the doctrine of revival. That is, the doctrine of origin can be revived. When a person who has acquired domicile of choice leaves that country for the purpose of another domicile of choice, the domicile of origin will revive and will be in operation until the new domicile of choice is acquired. Domicile of choice is not subjected to doctrine of revival. So once a person leaves the country in which he has domicile of choice with animo non revertendi, the domicile of choice is taken away forever. Now, in a case that is Bell versus Kennedy, 1868. Bell versus Kennedy. Bell was born in Jamaica and his domicile of origin was Jamaica. His parents were Scottish subjects. He was educated in Scotland. After education, he went to Jamaica and married there. After the marriage, he went to Scotland for settling there permanently. During the period when he was searching for a house in Scotland, his wife died. The question before the court was, what was his domicile at the time of her death? The court held that he was having Jamaican domicile of origin at the time of her death. Now the another one is Utney versus Udney. That is Udny. Utney versus Utney. The domicile of origin of Colonel Utney was Scotland. When he was 23, he moved to London and lived there for about 32 years with his family. Thereafter, he left England with animo non revertendi and went to France. He lived in France about 9 years without acquiring a fresh domicile of choice. The question before the court was, what was his domicile during the period when he was residing in France? When he left the domicile of choice with intention not to return, the domicile of choice is lost, and by virtue of doctrine of revival, the domicile of origin was revived, and during the period when he was in France, his domicile was Scotland. Now, another one, we have some general rules of domicile. Like why do we have doctrine of revival? Why can't a person stay without domicile until a new domicile is acquired? So these are based on the general rules of domicile. So there are 4 general rules relating to domicile. The first one, no person can be without a domicile. This rule is settled. It's a settled principle. Now the second one, a person cannot have 2 domiciles simultaneously. Then the third one, an existing domicile is presumed to continue until it is proved that a new domicile has been acquired. Strong proof would be required to displace a domicile of origin by a domicile of choice. And the fourth rule, in case involving foreign element, the question of domicile of a person will be determined only by applying English law by the English courts. So the determination of domicile, the English court will apply only the English law. So these are the main, the most important 4 general principles with respect to domicile. A person shall always have, cannot be without a domicile. He shall always have a domicile, and same way the person cannot have more than 2 domicile. So the first one, why a domicile? The person should always be subject to some jurisdiction or a certain laws. So the person should always have a domicile, and there should not be conflict between these the laws governing that person. So a person can have only one domicile at a time, and then the person should always have a domicile. So when the domicile by choice is revoked, there is doctrine of revival and domicile of origin comes into place. A person shall always have a domicile that is existing. So an existing domicile will continue to govern him or be his domicile until a new domicile of choice is acquired. And the last one, while deciding the domicile in any case with foreign element and the English court has to decide the domicile, then the English court will only apply English law to determine the domicile. Now, Indian law relating to domicile. The first one, domicile of origin. Now, here it is the relevant section we can quote here is Section 5 of Indian Succession Act. By Section 5 of Indian Succession Act, it deals with domicile of origin of minor children. The domicile of origin of every person of legitimate birth is the country in which at the time of his birth his father was domiciled. The domicile of origin of an illegitimate child is in the country in which at the time of his birth, his mother was domiciled. Now, the second one is acquisition of new domicile, that is domicile of choice. These are, we are discussing about Indian law. So far, we discussed about the English law, and now we are discussing about the Indian law, which is very much similar to the English law. So, under Indian law, domicile of origin, thus it is exactly the same as the English law. Now, acquisition of new domicile, that is domicile of choice. Here, section 10 of Indian Succession Act. So, domicile of origin, we can quote section 5 of Indian Succession Act, and domicile, acquiring of domicile or domicile by choice, we can quote section 10 of Indian Succession Act. It deals with the acquisition of domicile of choice. A man acquires a new domicile by taking up his fixed habitation in a country which is not that of his domicile of origin. Now, in a case that is Abdus Samad versus State of West Bengal, Abdus Samad versus State of West Bengal 1973. The Supreme Court observed that the term domicile means the place which a person had fixed as a habitation for himself and his family, not for a merry, special, or temporary purpose, but with a present intention of making it his permanent home. So, here the significance of intention was reiterated by the Indian court, that is the Supreme Court, in Abdus Samad versus State of West Bengal. Then, domicile of married women. With respect to English law, we discussed that the domicile of married women was abolished by the Domicile and Matrimonial Proceedings Act of 1973. So, here, with respect to Indian law, we can quote section 15 and section 16 of Indian Succession Act that deals with the domicile of married women. And with respect to that, by virtue of section 15, by marriage, a woman acquires the domicile of her husband if she has not the same domicile before marriage. A wife domicile during her marriage follows the domicile of her husband. Now, along with this, we also have to consider domicile of a company or corporation. A company or corporation is an artificial or legal person. According to English law, a company or corporation is domiciled in the country where it is incorporated or registered. Thus, if a company is registered in India, it is domiciled in India. Every individual gets a domicile by operation of law on his birth, namely the domicile of origin. So, a company's birth is by the incorporation, and thus it becomes the domicile of origin of the company or the corporation. So, a company is given a domicile of origin at the moment it is brought into existence. The domicile of origin of the company is the country where it is incorporated. An individual can acquire a new domicile of choice. That is not possible in the case of a company. A company can have only one domicile throughout its existence. Now, commercial domicile. Commercial domicile is a legal concept used to determine enemy character of a person or company during war. If a person or company voluntarily resides or carries on business in enemy territory, he or it is said to have commercial domicile of that country. So, if a person or company is voluntarily residing or carrying on business in an enemy territory, he or it is said to have commercial domicile of that country. The concept of commercial domicile is used to determine the liability of property to seizure. It is not domicile in the true sense. A person may have an ordinary domicile and one or more commercial domiciles at the same time. So that is with domicile. The next topic we have is tort, that is foreign tort. When a suit is filed in a country claiming compensation for a tort committed in a foreign country, the question normally arising is which law should be applied to decide the rights and liabilities of these parties. There are three theories to give answer to the above question, and that is theory of lex fori, the theory of lex loci telicity commissi, and the proper law of tort. So, the theory of lex fori. The theory of lex fori is of German origin. It was advocated by Savini in 1849. According to this theory, when a case comes before a court claiming compensation for a tort committed in a foreign country, the court should apply the law of the forum for deciding the rights and liabilities of the party. So, what this theory says is that no matter the foreign element, when it comes to the court, the law of the forum state or the court of the forum law of the court shall be applied. That is lex fori. Now, the fundamental defect of this theory is that a defendant would be liable if his act is actionable according to lex fori, although it is quite innocent according to the law of the country where the act was committed. Moreover, if the lex fori is the sole law, the plaintiff will select a country to file suit which is most favorable to him, and this may encourage what is called forum shopping, forum selection, forum shopping. So, there are two main issues here with respect to lex fori. So, no matter what kind of offense comes or where it was committed, the foreign element becomes immaterial when the theory of lex fori is applied. So, where the case is being instituted, the court will apply only their law, their forum law. That is the law of the country where the court is situated. Law of the forum state. That is what lex fori explains, or lex fori states. Now, the issues with this is that what is wrong or what is an offense in one state might not be wrong in another state. So, if the defendant is liable in state A, or if he is actionable, his action is actionable for tort in state A, it might not be in state B where the act was committed. So, if he is being liable in such a way, that is gross injustice to the defendant. Further, the plaintiff will choose the forum where he is most likely to get the most favorable uh, decision or outcome. So, if the plaintiff knows that the act of the defendant is actionable in state A and not actionable in state B, and the act was committed in state B where it is not actionable, the plaintiff would purposefully move a file in state A, because there the lex fori, the law of the state A, will be applied and he can claim a compensation. So that is forum selection, and that is also not a proper justice towards the defendant. Now, the second theory is theory of lex loci telicity commissi. That is the law where the act was committed, the law of that country will be applied. According to this theory, the liability for tort is to be governed by the law of the place where the tort was committed. As a general rule, application of lex loci telicity commissi will not bring about unjust result. However, mechanical application of lex loci telicity commissi may bring about unjust result. For example, an Englishman had an illicit sexual intercourse with the wife of another Englishman in India. According to the Indian law, the alleged wrong is not a tort but only a crime. If the aggrieved Englishman files a case in England, the English court will dismiss the suit by applying the Indian law. This may result in injustice. Thus, this theory is also not a sound theory. Now, the third theory is the proper law of tort. This theory is evolved in America due to the drawbacks of the theories of lex fori and lex loci telicity commissi. According to this theory, the law to be applied is that country's law with which the act complained of has most significant connection. That is, to which country the tort committed has the most significant connection, that is a real and substantial connection, the law of that country will be applied. The proper law of tort, that is law to be applied, is that country's law with which the alleged wrong or the tort has the most real and substantial connection. With respect to this, we have Babcock versus Jackson, a case, that is Babcock versus Jackson. The American court applied the theory of proper law of tort for selection of lex causae and applied New York law to decide the dispute. So, what is the fact of the case? So, in the plaintiff, the plaintiff was a gratuitous passenger in defendant's motor car. They were both domiciled in state of New York. So the plaintiff and defendant both were domiciled in New York. They went to Canada on a weekend trip. The plaintiff was injured in the state of Ontario due to the negligent driving of the defendant. According to the Lex Loci Delicity Committee, the driver have no liability towards gratuitous passenger. That is the Ontario law. The New York court applied the theory of proper law of tort and selected the New York law since the tort has most real and substantial connection with the New York. The connections considered by the court are: the plaintiff is domiciled in New York, the defendant is domiciled in New York, the car was registered in New York. According to New York law, a gratuitous passenger can also claim compensation from the negligent driver. So with respect to Ontario law, gratuitous passenger could not claim a compensation, but by New York law, gratuitous passenger could claim a compensation. Here, the New York law had the most real and substantial connection. The New York law was applied and the compensation was granted. This is Babcock versus Jackson. Now, the modern English law. The modern English law is a sort of compromise between the competing claims of Lex Fori and Lex Loci Delicity Committee. In order to find out the English law for the selection of law to be applied for deciding a case related to a foreign tort, one has to study 3 cases to understand the modern English law. So the first case here will be Phillips versus Eyre. Phillips versus Eyre. Then Machado versus Fontes. Machado versus Fontes. And the third one, Boyce versus Chaplin. Boyce versus Chaplin. So there is we can see a evolution of the there was a particular principle that was laid down by Phillips versus Eyre, and then we can see how this principle developed. So this is the modern English law. So the first case law, Phillips versus Eyre. So here Phillips, the plaintiff, filed a suit against Eyre claiming compensation for assault and false imprisonment. So what happened here was, Eyre was the governor of Jamaica, and he had executed martial law to suppress rebellion. So Philip had visited Jamaica during this period and he was imprisoned there, and later he was released. So Eyre, he left the office of governor of Jamaica and came back to England. The plaintiff and defendant both were domiciled in England, so he left the office of governor of Jamaica and he came back to England. When Eyre came back to England, Phillips filed a suit. So the defendant Eyre appeared in the court and raised a defense that his act in Jamaica in the process of suppressing rebellion is exempted from the liability by an act of indemnity passed by Jamaican Parliament. So while deciding the case, the English court laid down the following principles. That is 2. First one, in order to file a suit in England for a wrong alleged to have been committed abroad, the wrong must be actionable in England. So if one has to move to the English court for remedy in foreign tort, the particular wrong committed should be actionable in English court also. Now the second one, the act must not be justifiable by the law of the place where it was done. So this particular act, it shall not be justified at the place where it was committed. So these were the two principles that was laid down by the English court to determine how to decide on this case. Here the court held that the defendant's act, that is the heir who was the governor of Jamaica, his act of imprisoning Phillips was justified by law because there was a martial law existing in Jamaica when he visited there, and this martial law was to suppress the rebellion there. So the defendant's act was justified by Jamaican law. So, and it is not the plaintiff cannot move a suit for remedy for foreign tort against defendant. And then we have Machado versus Fontes. Here the defendant published a defamatory matter in libel form in Brazil. So the defendant published a defamatory matter in libel form in Brazil. The plaintiff filed a suit in England claiming compensation. According to Brazilian law, libel is only a crime and not a tort. The defendant contended that this act is not a tort according to Lex Loci Deliciti Commissi. The English court held that the alleged wrong is actionable in England and the defendant's act was not justifiable in Lex Loci Deliciti Commissi, and thus the defendant is liable to pay compensation. So in Philip versus Iyer, two principles was laid down. It should be actionable in English court as well as not justifiable by law at the place where it was committed. Here, by Brazil law, libel was a crime. So it was not justifiable by the Brazilian law, and libel is a tort and actionable in English court. So both the principles were met and the court held that the defendant is liable for compensation. Now, this decision was severely criticized by many jurists. The decision in Machado versus Fontes thus has been overruled by House of Lords in the decision of Boyce versus Chaplin. So first we saw the phase where the principles were laid down. Then we saw the application where the criminal liability in the place where it was committed was also considered for as a tort in English court. And then the next evolution we are going to see is Boyce versus Chaplin. So here there was one more condition or one more principle that was added to the existing principles of Phillips versus Iyer. So that is Boyce versus Chaplin. Machado versus Fontes was overruled by Boyce versus Chaplin. Here the plaintiff, that is a Boyce, and the defendant, who is Chaplin, were both in British service and was stationed in Malta. The plaintiff was injured in Malta due to the negligent driving of Chaplin. According to the Maltese law, the plaintiff could recover 53 pounds as compensation. But according to the English law, the plaintiff could recover 2,000 pounds as compensation. So the House of Lords, while deciding the case, declared the following principles. Now, first is the same. The act should be actionable as a tort by English court domestic law. So the act should be actionable as a tort by English domestic law. Then the second condition is that there should be civil liability according to Lex Loci Deliciti Commissi. So if there is only criminal liability, then the action will fail. So this is the part where the Machado versus Fontes was overruled. So here in Boyce versus Chaplin, the court said that there should be civil liability according to Lex Loci Deliciti Commissi. If there is only criminal liability, the action will fail. And the third condition, the act must not be justified by law at the place where it was done. Now, if all the above conditions are satisfied, the foreign tort is actionable in England, and in assessing the liability, that is the amount of compensation, the English law will be applied by the English court. So that is with the how the modern English law evolved and the theories in foreign tort. Now, when we discuss about foreign tort, we also have maritime tort. The expression maritime torts refers to the torts committed in the sea. In the case of torts committed within the maritime belt of a country, the locus delicti, that is a local limit, is deemed to be the literal state, and the rule in Phillips versus Eyre as modified by Boyce versus Chaplin applies. Now, if the tort is committed on board a ship by one passenger on another, the law of the state whose flag is flown in the ship is applicable. So it is within the it is on the board of the ship and it is between the passengers. The flag bearer country is law will be applicable. Now, in case of torts such as negligent navigation leading to a collision or destruction of a submarine cable, the general maritime law administered by the Admiralty Division of the High Court, that is general maritime law administered by the Admiralty Division of the High Court, is applicable if the act in question is one that is covered by the international convention. The rules of the conventions becomes applicable. So that is with the foreign tort. The next topic we have is contract. When a case connected with a contract which containing foreign element comes before an English court, the problem of ascertaining the lex causae would arise. The problem of ascertaining the lex causae is more difficult in the case of contracts. The contract may be made in one country and the place of performance may be another country. The parties may be domiciled in yet another country. So, it is very difficult to determine the lex causae. In such situation, the problem of selection of lex causae would normally arise. In order to solve the problem of ascertaining lex causae, the English private international law has evolved principles of proper law of contract. So earlier we discussed proper law of tort, and now we will discuss about proper law of contract. The proper law of contract has to be applied in determining rights and liabilities under a contract. In order to ascertain the proper law, there are two theories. They are the theory of intention, that is the subjective theory, and localization theory, that is the objective theory. Now, according to the theory of intention, proper law is that law which the parties have chosen and intended to apply. If the parties have chosen a particular law under which their rights and obligations are to be determined, this chosen law is the proper law of contract. Then we have localization theory or the objective theory. According to the localization theory, the proper law of contract is the law of the country in which the elements of the contract are most densely grouped. According to this theory, in order to find out the lex causae or proper law of the contract, the elements of the contract are to be analyzed and find out the country in which the elements of the contract are most densely grouped. So we are giving importance to elements of the contract and where they are most densely grouped. That is in localization theory or the objective theory. Now, in words of Westlake, proper law should be the law of the country with which the transaction has the most real connection, real and substantial connection. This theory is also known as objective theory. Now, modern English law for ascertaining proper law. The modern English law is a compromise of the two theories, that is the subjective theory and objective theory. The subjective theory emphasizes on the intention of the parties where they have chosen to where they have chosen for the law to govern their rights and liabilities, and the objective theory considers the elements in the contract and the country in which where they are densely grouped. So, the modern English law for ascertaining proper law is a mix of subjective theory as well as the objective theory. If the parties to the contract have expressly chosen a particular law, the court should apply that law for determining the rights and liabilities of the parties. When the intention of the parties with regard to the law governing the contract is not expressly or impliedly stated, then the court has to apply the localization theory and find out the proper law. So, we have Vita Food Products Incorporation versus UNS Shipping Company. So, the case law we are going to discuss first is Vita Food Products Incorporation versus UNS Shipping Company, 1939. In this case, the English court established the principle that if the parties have expressly selected a system of law as the proper law applicable to their contract, the court should apply that law. The parties are free to choose any system of law as the proper law even though the contract has no connection with that country. So it is important, the parties are free to choose any system of law as a proper law even though the contract has no connection with that country. So that was said in Vita Food Products Incorporation. Vita Food Products Incorporation versus UNS Shipping Company. Vita Food Products Incorporation versus UNS Shipping Company, 1939. Now, according to Lord Atkin, if the intention is clearly expressed, it is conclusive. So, according to Lord Atkin, if the intention is clearly expressed, it is conclusive. In this case, the defendant company was incorporated in Nova Scotia. That is, UNS Shipping Company was incorporated in Nova Scotia. The plaintiff was a New York firm. So the plaintiff was from New York and the defendant in Nova Scotia. They entered into the agreement at Newfoundland and the defendant agreed to carry a cargo in a Nova Scotian ship and deliver them to the plaintiff at New York. According to law of Newfoundland, the defendant company is not liable for negligence of the master of the ship. The parties have expressly provided in the contract that the contract would be governed by the English law. The cargo was damaged due to the negligence of the master of the ship. The plaintiff sued the defendant in New Scotia for damages. The defendant contended that according to the Newfoundland, that is where the contract was entered into, they are not liable for the negligence of the master of the ship. But the Privy Council held that the proper law of the contract is the law which the parties have expressly selected. In this case, the parties have expressly selected the English law and thus the defendant is liable. Now, another case, that is the Asunción case, that is in 1954. This case may be cited as an illustrative case which was decided by the English court by applying localization theory. So, in case of Vita Food Products Incorporation versus UNS Shipping Company, we applied the subjective theory or the intention theory, the theory of intention. Now, we are going to discuss about the Asunción case, 1954. It is dealing with the objective theory. Now, the contract was for carriage of wheat from French port to an Italian port on board on Italian ship. So it was from French port to Italian port and on Italian ship. The charter party was an organization of French merchant. The wheat was shipped under an exchange agreement between French government and Italian government. The contract was concluded in France by French and Italian brokers. The contract was drawn up in English language but supplemented in French language. Freight and demurrage was payable in Italian currency in Italy. The bill of lading was endorsed to consignees in Italy. The question before the court was, what is the proper law of contract? So there is French, the transfer is from French port to Italian port, and it is an Italian ship. It is an Italian ship, and the charter party was an organization of French merchant, and the agreement was entered at France by French and Italian brokers, and the contract, it was drawn up in English with supplement of French language. Then the freight and demurrage were payable by Italian currency, and the consignees, the bill of lading was endorsed to the consignees in Italy. Now, with these facts, in this case, the parties have not expressly selected a law to be applied for deciding the dispute. When the intention of the parties to a contract with regard to a law governing it is not expressed, the contract is governed by the system of law with which the transaction has its closest and more real connection. In order to find out that country with which the transaction has more connection, the elements of the contract are to be analyzed and grouped. So the facts are gonna be analyzed. So the first one, the contract was concluded in France. Then the charter were French merchant, and the French brokers were acting on behalf of French government. Then the contract was written in French language, written in English language, but had a French language supplemented in French language also. Now all these support the French law. These 4 points support French law. Now let's see what supports the Italian law. So the ship itself was Italian, and the place of performance, that is, it was payable in Italian currency and at Italy. So the performance was at Italy, and this was to be, the destination port was Italy. So place of performance is Italy. The freight and demurrage were payable in Italian currency. The bill of lading was endorsed to consignee in Italy. The Italian brokers were acting on behalf of the Italian government. So considering the weightage of French law and the Italian law, the Court of Appeal held that the Italian law was the proper law of the contract. Now, when the proper law is not the only law applicable, there are certain areas in the law of contracts where some other law over and above the proper law becomes relevant. That is, when illegality, formal validity, and capacity of the parties comes into action or comes in the purview. Illegality. In order to decide the question of illegality of a contract, in addition to the proper law, the English court will consider lex fori, lex loci contractus, and lex loci solutionis. So, what will be in addition to the proper law, what will the English court consider? That is the lex fori, then lex loci contractus, where the contract was entered into, and lex loci solutionis. So these laws are also relevant. That is with respect to illegality. Question of illegality. Then comes the question of formal validity. When the question of formal validity arises, the English court will consider not only the proper law but also the lex loci contractus, that is the law of the land where the contract was entered into. Now the third one is capacity of parties. There is no clear English authority to indicate the law which governs the question of capacity to enter into contract. So that is with contract or foreign contract. We discussed proper law and the two wings of proper law, that is the subjective theory and objective theory, and the exceptions. and that is with foreign contracts. The next topic we have is marriage. Marriage, whether arising out of contract or sacrament, creates status. Marriage is a contract of a special kind. It can be concluded only by a formal or public act. It can be dissolved only by a formal or public act. So it can be concluded only by a formal or public act. Similarly, it can be dissolved also only by a formal or public act. The concept of Christian marriage was defined in height versus height. It defines that a marriage is a voluntary union for life of one man and one woman to the exclusion of all others. So, a marriage is the voluntary union for life of one man and one woman to the exclusion of all others. The requirements of an English marriage are the following: 1. The union should be voluntary, and 2. It should be monogamous, and the third one, it must be for life and not for a limited period. So what are the three conditions for English marriage? It should be voluntary, it should be monogamous, and it should be for life and not for a limited period. So in height versus height, the English court held that the parties to a polygamous or potentially polygamous marriage are not entitled to any matrimonial relief such as divorce, nullity of marriage, etc. The polygamous and polyandry marriages are not marriages in the eye of English law, and thus parties to such marriage cannot claim any matrimonial relief from any English court. Now towards the fact of the case, that is height versus height. The petitioner was an Englishman who embraced the Mormon faith. He went to Utah in USA and married a Mormon lady according to Mormon faith. He cohabited with her for 3 years, and having children by her, he renounced Mormon faith. He came back to England and became the minister of a dissenting chapel. He was expelled from the Mormon faith and his wife married another man in Utah. He filed a petition in England for divorce. The English court held that the Mormon marriage was potentially polygamous, and the party to polygamous or potentially polygamous marriage are not entitled to any matrimonial relief from an English court. The relevant law to decide the nature of marriage is the law of the place where the marriage was celebrated, that is, lex loci celebrationis. The English matrimonial relief would be available to parties whose personal law allows the English matrimonial relief will be available to parties whose personal law allows polygamy if the marriage is solemnized in England and in English form. So even if the personal law allows polygamy, the English courts or English law will provide matrimonial relief if it is solemnized in England and in English form, because they are the English law is considering to understand whether it's a monogamous marriage or polygamous marriage. The law that governs is the lex loci celebrationis, that is the law of the place where the marriage was celebrated. So even if the personal law, for example, if a Muslim person, an Indian Muslim, so polygamy is allowed for them. If he is getting married in England in English form, that marriage will be a Christian marriage or a monogamous marriage. A marriage at the inception may be polygamous, and at the time of institution of the proceedings in English court, the nature of marriage may change due to change to monogamous. In such a case, the English court will entertain the petition of the matrimonial relief. So even if the marriage is polygamous at the inception and later it changes to monogamous, even in that situation the English court will entertain petition for matrimonial relief. The change of nature of marriage may occur due to variety of reasons, such as change of religion, change of domicile, change of personal law, etc. So here we have a case, that is Cheney versus Cheney. According to Jewish law, a marriage between two Jews is potentially polygamous because the husband can take a second wife if there is no child within 10 years in the first marriage. In this case, the wife filed a petition for a matrimonial relief. A child was born within 2 years of the first marriage. The court held that the first marriage was potentially polygamous at the inception, but the nature was changed to monogamous due to the birth of the child. So the court entertained the suit. So that was Cheney versus Cheney. Now, Sinha peerage claim. Here, marriage between two Hindus was potentially polygamous before 1955. It was by Hindu Marriage Act of 1955 that the the marriages of Hindu males became monogamous, or bigamy was not allowed. Before that, it was polygamous. They were allowed to have polygamous marriage. So, marriage between two Hindus was potentially polygamous before 1955. In 1880, two Hindus married according to the Hindu law. The marriage was potentially polygamous. After the marriage, both the spouses joined the Brahma Samaj. The followers of Brahma Samaj could not have more than one wife. So the change of faith resulted in the change of nature of marriage. So by the change of faith, the polygamous marriage become monogamous marriage. Then another case law, that is Ali versus Ali. Here two Muslims who domiciled in India married in India according to Muslim law. The marriage was potentially polygamous. Subsequently, they acquired English domicile of choice. The English law has not permitted the husband to have more than one wife. The wife deserted the husband and the husband filed a petition for divorce. The court held that change of domicile resulted in the change of marriage, and at the time of institution of the suit, the marriage was monogamous. So these are all examples where there is a change of nature of marriage from polygamous to monogamous. So in Cheney versus Cheney, that is the marriage of two Jews, here the birth of the child changed the nature of the marriage. And in Sinha peerage claim, here the marriage between two Hindus, the change of faith made the potentially polygamous marriage to monogamous. And in Ali versus Ali, here the potentially polygamous marriage was changed to monogamous marriage by change in domicile by choice. Now, to what extent polygamous marriage are recognized by English court? So if we are not to if the English court does not recognize polygamous or potentially polygamous marriages at all, it can lead to a lot of injustice to the people or its subject. So polygamous marriages are recognized by the English court to one particular extent in special cases. So to what extent and under what circumstances is the polygamous or potentially polygamous marriages recognized by the English court? The first one is for recognition as a bar to subsequent marriage, and the second one for the enforcement of proprietary rights under the personal law. The third one is for conferring legitimacy to children. The fourth one to determine the right of succession. Then the fifth one to recognize the right of succession of widows. Then the sixth one to confer benefit of social security legislation. So these are the 6 scenarios or circumstances where polygamous marriage or potentially polygamous marriages is recognized by English court to an extent. The first one is as a bar to subsequent marriage. Then the second one enforced for the enforcement of proprietary rights under the personal law. The third one for conferring legitimacy to children. The fourth one to determine the right of succession. The fifth one, to recognize the right of succession of widows. Then the sixth one, to confer benefits of social security legislations. So in Hyde versus Hyde, the English court held that parties to a polygamous or potentially polygamous marriage are not entitled to any matrimonial relief from the English courts. The strict adherence to this principle may sometimes do injustice to the parties to the marriage. So the English courts have recognized polygamous and potential polygamous marriage for certain limited purposes. The English courts have recognized the potential polygamous marriage in the previously discussed six situations or circumstances. So going further, we are going to discuss into recognition as a bar to subsequent marriage. The English courts will recognize a polygamous marriage as marriage for the purpose of barring a party to such marriage from marrying again in England. So we have a relevant case law here, that is Baindale versus Baindale. Here, an Indian domiciled Hindu married an Indian woman in India according to Hindu rites. In those days, Hindu law recognized polygamous marriage, that is prior to 1955. The husband went to England and married an English lady in England in English form, suppressing the information about the Indian marriage. Later, the English wife filed a petition for nullity of marriage in England on the ground that her husband has another wife living in India. The Indian marriage was potentially polygamous. The English court did not recognize the Indian marriage, and then the second marriage in England could not be declared null and void, and that will be injustice. Thus, the English court held that the Indian marriage was valid for the purpose of barring subsequent marriage in England. So, the Indian marriage was recognized only for the purpose of barring subsequent marriage in England. And that is the case of Baindale versus Baindale in 1946. Now, the second scenario or circumstances for the enforcement of proprietary rights under the personal law. If the personal law of the parties to a potentially polygamous marriage confers some proprietary rights upon the parties, that is, dower claim, maintenance as such, in order to recognize such rights, the English court would recognize potentially polygamous marriage as a valid marriage. That is for the recognition of proprietary rights such as dower, maintenance, etc. And the third circumstance is for conferring legitimacy to children. In order to confer legitimacy to children born in polygamous or potentially polygamous marriage, the English court would recognize such marriage as valid marriage, because no law system wants to bastardize any child, and they always prefer for the legitimacy and legitimization of the children. So, to confer legitimacy to the children or born out of polygamous or potentially polygamous marriage, such marriages will be recognized. Now, the fourth circumstance is to determine the right of succession. In order to recognize the right of succession of children born in a polygamous wedlock or potentially polygamous marriage, the English court would recognize such marriage as valid marriage. Then the fifth circumstance is to recognize the right of succession of widows. Now, the English court would recognize polygamous marriage or potentially polygamous marriage as valid marriage for the purpose of recognizing right of succession of widows. And the sixth circumstance is to confer benefit of social security legislations. The English courts would recognize polygamous marriages as valid marriage for the purpose of conferring benefits of social security legislations to widows and deserted wives of polygamous marriages. Now, validity of marriage. We said that polygamous marriage and potentially polygamous marriage are not Christian marriages, or not dealt valid marriage under the English court. But this is not the sole criteria of determining the validity of marriage. So we are going to look into the validity of marriage. When a case related to marriage comes before the English court, the question of formal validity and essential validity might rise. So formal validity. In order to determine the formal validity of a marriage, the English court will apply lex loci celebrationis. So the formal validity is determined by the English court by applying lex loci celebrationis, which means law of the place where the marriage was celebrated. A marriage which is formally valid according to the law of the place where marriage was celebrated would be declared valid by the English court even though it is invalid according to the English law. Now, there are certain exceptions to the general rule that a marriage which do not satisfy the formal requirements of lex loci celebrationis is invalid. There are certain exceptions to the general rule. Under the following circumstance, a marriage is regarded as valid even though it has failed to observe the formal requirements of lex loci celebrationis. And that is the first one. There are three exceptions. The first one, consular marriage. The second, marriage of members of British forces serving abroad. And the third one, common law marriages. So, consular marriage. By virtue of the Foreign Marriages Act of England, by virtue of Foreign Marriages Act of England, a marriage solemnized before a marriage officer in a foreign country would be valid if one of the parties is a British subject. Now, the second one, marriage of members of British forces serving abroad. A marriage of a member of British armed force serving in a foreign country will be formally valid if it was celebrated by the chaplain serving with the force or by the authorized commanding officer. Now, common law marriage. The third one is common law marriage. If there is an unsuperable difficulty in following the formalities of lex loci celebrationis, the marriage will be regarded as formally valid if the marriage is celebrated in accordance with the requirements of English common law. The requirements of English common law are: the first one, the parties should take each other as husband and wife. The second, an episcopally ordained priest should perform the ceremony. So that is with formal validity. And then we have essential validity. Under essential validity, we have two important theories, that is dual domicile theory and intended matrimonial home theory. Then, essential validity. When a question of essential validity of marriage arises in an English court, normally the question regarding the law to be applied for determining the validity of marriage would arise. The question of capacity of parties to the marriage is a question of essential validity of marriage. When such a question arises, the court has to apply a law to determine the validity of the marriage. In order to select the law to be applied by the court, there are two theories, that is the dual domicile theory and intended matrimonial theory. Dual domicile theory. According to this theory, a marriage is invalid unless, according to the law of domicile of both the parties at the time of marriage, they have the capacity for marriage. In order to determine the capacity of the parties to a marriage, the law of antenuptial domicile of both the parties, have to be considered by the English court. If they have capacity as per the law of the domicile before their marriage, the marriage will be declared valid. Then the second theory is intended matrimonial home theory. According to this theory, The capacity to marriage should be governed by the law of the country where the parties at the time of marriage intends to establish their matrimonial home and actually established their matrimonial home. Now, with English law, when we examine the decisions of the English court, we could see that the English courts have given recognition to both the theories, that is, dual domicile theory as well as intended matrimonial home theory. However, most of the English cases strongly support the dual domicile theory. In that, we have Brooke versus Brooke. Here, a marriage was celebrated in Denmark between a domiciled Englishman and his deceased wife's sister, also English domicile. So, both the man and woman was English domiciled. It was celebrated in Denmark, but the bride was the deceased wife's sister. Marriage between a man and his deceased wife's sister was legal by Danish law, but was illegal by English law at that time. The House of Lords applied the dual domicile theory and held that the marriage was invalid. Now, another case is Mette versus Mette. In this case, an English domiciled man married his deceased wife's sister of German domicile. The marriage was celebrated in Germany, and after the marriage, they settled at England. The marriage was valid by German law but invalid by English law. The court held that the marriage was invalid according to both the theories, because the intended home was also England, and by dual domicile theory also, the Englishman did not have capacity, so it was invalid according to both the theories. Then we have another case, that is Padolaccia versus Padolaccia. Here, P was domiciled in Italy. He married in Italy and obtained a decree of divorce by proxy from a Mexican court. This decree would not be recognized by Italian law. Subsequently, he went to Denmark, and while there, he made one-day visit to England and married a woman domiciled in Denmark. After this marriage, they returned to Denmark to establish their matrimonial home. Subsequently, P filed a case in England for declaration of nullity of his second marriage. The court considered the capacity of P to marry the second wife. The court found that the Mexican decree was not valid, and thus the first marriage is valid. Then the second marriage is invalid and void, since the husband had no capacity. The court applied the dual domicile theory here. So that is with marriages. Now, going forward with matrimonial causes. So, the question is, when can an English court grant a decree of divorce, or the jurisdiction of English court to grant a decree of divorce or nullity of marriage, etc. Matrimonial causes. So, when a party to a marriage approaches an English court for a decree of divorce, the question of jurisdiction of English court would arise. And in this respect, we have a case law, that is Le Mesurier versus Le Mesurier, 1895. Here, the English court held that only the courts of the country where the husband was domiciled at the time of institution of the proceedings were competent to entertain suit for dissolution of marriage. When a suit for dissolution of marriage was instituted before an English court, the sole question was whether, at the time of the institution of the suit, the husband was domiciled in England. If the husband is not domiciled in England, the English court would not exercise its jurisdiction even though the parties are residing in England or they have voluntarily submitted to the jurisdiction. So this was held in Le Mesurier versus Le Mesurier. The strict adherence to the principle in Le Mesurier versus Le Mesurier caused injustice to the deserted wife. If the husband who had English domicile deserted his wife in England
and acquired domicile of a new country, the deserted wife could not obtain a decree of divorce from an English court. In order to mitigate the difficulties of the deserted wife, the Parliament enacted Matrimonial Causes Act of 1937. Matrimonial Causes Act of 1937. Now this act enabled wife to petition for divorce if she was deserted by her husband, and before desertion her husband was domiciled in England. So the ruling in Le Mesurier versus Le Mesurier was gross injustice, and that is why Matrimonial Causes Act of 1937 was brought. By this act, the deserted wife could petition for divorce if she was deserted by her husband, and before desertion her husband was domiciled in England. In 1949, the Parliament enacted Law Reforms Miscellaneous Provisions Act. So this was Matrimonial Causes Act came in 1937, and in 1949 the Parliament enacted the Law Reforms Miscellaneous Provisions Act and provided that the courts in England can entertain a divorce petition filed by the wife if she is resident in England and at least for a period of 3 years before the commencement of the proceeding, even though the husband is not domiciled in England. So the first phase was in Le Mesurier versus Le Mesurier, that is 1895. The court said only if the husband is domiciled and resident in England, the English court has jurisdiction. Later, the Matrimonial Causes Act of 1937 was brought. By this act, the deserted wife could apply for a petition for a divorce if she was deserted, and before desertion the husband was domiciled in England. And then in 1949, the Law Reforms Miscellaneous Provisions Act came into being. By this, the wife can petition if the wife is resident in England at least for 3 years before the commencement of the proceedings, immaterial if the husband is resident or domiciled in England. Then later in 1973, the Parliament enacted the Domicile and Matrimonial Proceedings Act. Domicile and Matrimonial Proceedings Act in 1973. By virtue of this provision of the English court can exercise jurisdiction to grant decree of divorce if any one of the following two conditions are satisfied. So the first one, if either of the parties, that is the wife or the husband, is domiciled in England at the time of institution of the proceedings. And the second condition, if either party was habitually resident in England throughout the period of 1 year up to the date of commencement of the proceeding. So, if either of the conditions is satisfied by the 1973 Domicile and Matrimonial Proceedings Act, the English court can grant the decree of divorce. Now, the choice of law or the selection of lex causa. Once the English court assumes jurisdiction to grant the decree of divorce, it will apply English law, that is lex fori, for deciding the merits of the case. Any other legal system such as lex domicilia or lex patriae or lex loci celebrationis, that is law of the domicile or the law of the nationality or law of the place where the marriage was celebrated, would be completely irrelevant. Only lex fori will be applied. Thus, if as per the English law there is a ground for granting divorce, the English court would grant it, even though as per the law of domicile or nationality that is not a ground. So that is with the matrimonial causes and remedies and who can apply and how the locus standi of the wife has evolved. In the beginning, it was only if the husband was resident and domiciled in England, and later by Matrimonial Causes Act 1937, if the wife was deserted, and before desertion, if the husband was domiciled in England, the wife could petition for divorce. And later in 1949 came the Law Reforms Miscellaneous Provisions Act. By this, if the wife was resident at least for 3 years immaterial of the husband's residence or domicile, the wife could petition for divorce. And by the 1973 Domicile and Matrimonial Proceedings Act, two conditions were laid down. If either of the conditions are satisfied, then a grant for decree of divorce could be given. And the two conditions are if either of the parties are domiciled in England, or if either of the party is habitually resident in England for a minimum of 1 year before the commencement of the proceeding. And then we have choice of law, where the English court will apply only lex fori, and the lex domicilia, lex patria, or lex loci celebrationis is irrelevant. So that is with matrimonial causes. Now we have discussed marriage, matrimonial causes, and now recognition of foreign decree of divorce. When a foreign decree of divorce is produced before the English court for its recognition, the English court will be guided by the private international law of England. The question of recognition of foreign decree of divorce is to be decided by the English court by applying the relevant rules. The common law rule was that the English courts would recognize the decree of divorce granted by the courts of the country where the parties were domiciled at the time of the proceeding. Thus, the English courts did not recognize any decree given by non-domiciliary courts. So, this was the initial rule. The English courts have subsequently changed its view and started to recognize decrees of divorce of non-domiciliary courts also. The evolution of this law can be studied by examining some decisions of the English court. The first one is Armitage versus Attorney General. Armitage versus Attorney General, that is 1906. In this case, the English court held that a foreign decree of divorce granted by a non-domiciliary court would be recognized by the English court if it would be recognized by the courts of the country where the parties were domiciled at the time of the proceeding. So initially the court accepted only the decision from the court where the parties were domiciled, and then the next phase was Armitage versus Attorney General. That is, here the divorce granted by domiciliary court would be recognized if it is recognized by the courts of the country where the parties were domiciled at the time of the proceeding. So in this case, that is Armitage versus Attorney General, X, the English wife of an American citizen domiciled in New York, obtained a decree of divorce from a court in South Dakota. The decree of divorce granted by South Dakota court would be recognized by New York court, and hence the English court held that it would be recognized the decree of divorce granted by South Dakota court. So the X is an English wife of an American citizen and domiciled in New York, and the divorce decree was from South Dakota. And yet the English court accepted it because this decree would have been accepted by New York court. Now, another case law, that is Travers versus Hawley, and that is 1955. Armitage versus Attorney General was in 1906, and then Travers versus Hawley, that is in 1955. In this case, the English court held that a decree of divorce granted by a non-domiciliary court would be recognized by English court, provided that the court which granted the decree of divorce should have exercised jurisdiction on the same jurisdiction of the circumstances existed in England. So here the husband and the wife were married in England. They were domiciled in England at that time. Subsequently, they acquired domicile of choice of another country, and that is New South Wales. While there, the husband deserted the wife and came back to England. The wife filed a petition for decree of divorce before the New South Wales court. The court of New South Wales exercised jurisdiction on the ground that the husband had domicile of New South Wales before the institution of the proceeding. In England also, the same jurisdictional circumstance, a divorce petition would be entertained. The Court of New South Wales granted a decree of divorce. The English court recognized it even though it was a decree of a non-domiciliary court. So, that is the third phase of the evolution. Here, the English court accepted the non-domiciliary court decree on the basis that the court should have exercised jurisdiction on the same jurisdiction of circumstance existed in England. Now, the next phase is that is explained by Indica versus Indica, that is in 1967. So the first Armitage case was in 1906. Then the next case, that is the Travers versus Hawley, was in 1955, and then Indica versus Indica is in 1967. In this case, the English court held that a foreign decree of divorce would be recognized by the English court if, at the time of the proceedings, there was a real and substantial connection between the petitioner and the foreign court. So, in this fourth phase, a real and substantial connection between the petitioner and the plaintiff, the petitioner and the foreign court was considered. So, Rudolf Indica, whose domicile of origin was Czechoslovakia, first married Helena in Czechoslovakia. During the Second World War, he was in resistance movement and was fighting the Germans outside Czechoslovakia and was unable to communicate with Helena. After the war in 1946, he settled in England and acquired English domicile of choice. He had not returned to his home state. In 1949, Helena obtained a decree of divorce from Czechoslovakian court. In 1959, Indica married an English lady, Rose, in England. In 1965, Rose filed a petition to English court for divorce. Indica contended that the English marriage is null and void because his Czechoslovakian wife is still alive. Then the question of recognition of Czechoslovakian decree of divorce arose in the English court. The court recognized the Czechoslovakian decree of divorce. While deciding this case, the House of Lords declared that the English court would recognize foreign decree of divorce if there is real and substantial connection between the petitioner and the foreign country. This decision made unclear the area where the law should be more clear. The uncertainty generated by the decision in Indica versus Indica resulted in the enunciation of two enactments by the British Parliament. They are Recognition of Divorces and Legal Separation Act 1971. Recognition of Divorces and Legal Separation Act 1971 and the Domicile and Matrimonial Proceedings Act of 1973. The Domicile and Matrimonial Proceedings Act of 1973. Now, by virtue of the provision of these enactments, the following decree of divorce would be recognized by the English court. That is, 1. Decree of divorce granted by the domiciliary court. 2nd, decree of divorce which would be recognized by the domiciliary court. 3rd, decree of divorce granted by a court in a country where either spouse was habitually resident. Now, decree of divorce granted by nationality court of either party. Now, recognition of extrajudicial divorce. Some religious laws allow one of the parties to marriage to divorce the other by unilateral acts without approaching a court for a decree or divorce. According to Jewish law, a husband can dissolve his marriage by delivering to his wife a letter of divorce called get. Under Muslim law, a husband is permitted to divorce his wife by talaq pronounced in the presence of a witness without assigning any reason. Sometimes the question of recognition of extrajudicial divorces would arise. Originally, the English courts were reluctant to recognize such divorces. Later, the English court began to show a tendency to recognize extrajudicial divorces. So, we have Hammersmith marriage case, that is 1970. Hammersmith marriage case. The husband, a Muslim, domiciled in India, married an English woman in England in English form. He divorced her wife by talaq, pronounced in London, in the presence of witnesses, but in the absence of the wife. The court refused to recognize this divorce mainly for three reasons. 1. It had not been granted by a court. 2. It was contrary to the principles of natural justice. 3. Talaq divorce is applicable only to Muslim marriages contracted in England. So that is with Hammersmith marriage case. Then we have Russ versus Russ. A Mohammedan domiciled in Egypt married an English woman in England. They lived in Egypt for 19 years. The husband divorced his wife by talaq declared before an officer of Sharia court. It was in the presence of witness and wife. The English court recognized the talaq divorce. Now, another case law, that is Qureshi versus Qureshi, 1972. The husband and wife were domiciled in Pakistan. The marriage was contracted in England according to the Muslim law. The husband pronounced talaq in England. The court recognized the talaq divorce. If the husband who divorced his wife by talaq was at the time of divorce domiciled in England, the English court would not recognize the divorce even though the husband is a Muslim and the marriage was a Muslim marriage. This position was declared by the English court in Manning versus Manning. We have already discussed such an example earlier where where a potentially polygamous marriage changes into a monogamous marriage by change in domicile by choice. So, if the Muslim who carried out the marriage as a Muslim marriage, which is potentially polygamous or polygamous marriage, when he acquires the English domicile, the marriage will automatically change to have a monogamous nature by the change in domicile by choice. So, if the Muslim had domicile in England, the English court would not recognize the divorce. Now, Quasi versus Quasi, that is 1979. The husband and the wife were domiciled in Pakistan and the husband effected a divorce by talaq. The English court recognized this divorce. So, that is with the recognition of foreign decree of divorce.
So the next topic is legitimacy, legitimation and custody. A child born within lawful wedlock has been considered to be a legitimate child, and a child who is born outside the lawful wedlock has been considered to be an illegitimate child. These traditional definitions of illegitimate and legitimate children have undergone some modification. So in the present scenario, that is the modern English law as well as the Hindu law, the children of annulled voidable marriages and of certain void marriages are regarded as legitimate children. The law to be applied is the law of domicile or lex domicilia. A child born anywhere is legitimate if born within the lawful wedlock. Now, a child is legitimate if the law of the father's domicile or habitual residence regards him as legitimate. So, it depends upon the father's domicile or habitual residence. If the legitimacy of a child is determined under two systems of law, then the law most favorable to the child should be applied. So we have a case law here, that is Shaw versus Gold. The question before the English court was the determination of the legitimate status of a child. In this case, a testator domiciled in England bequeathed certain funds in trust for Elizabeth Hickson for life, and after her death in trust for her children. The will also devised some English lands after her death to her first and other sons lawfully begotten.
Elizabeth, when she was only 16 years old, was induced fraudulently by one Buxton, a domiciled Englishman, to marry him in England. But she was taken away by her parents just after the marriage ceremony, and the marriage was never consummated. After some years, Elizabeth wanted to marry another English domiciled man named Shaw. And here, in order to facilitate the divorce of her marriage with Buxton, they devised their plan, and after paying some money to Buxton, he went to Scotland and resided there for 40 days. This enabled him to obtain a domicile in Scotland, and on the basis of this domicile, a Scottish court granted a decree of divorce dissolving the marriage between Buxton and Elizabeth. Here, after this, Elizabeth married Shaw in Scotland. They lived together in Scotland, and Shaw acquired a Scottish domicile of choice. During the lifetime of Buxton, 2 daughters and 1 son were born to Elizabeth from Shaw in Scotland. The question before the court was whether the children born to Elizabeth from Shaw was legitimate. According to the Scottish law, the children are legitimate, but the House of Lords held that the children are illegitimate because, in the eye of English law, Buxton continued to have his English domicile and his marriage with Elizabeth continued to be in force during the lifetime of Buxton. Elizabeth's subsequent marriage with Shaw was invalid and the children were held to be illegitimate. When a claim is made by a child over the property of his parents on the basis of bequest, it is made clear that the benefit is made available to a legitimate child. The question of legitimacy will be decided by applying the law of domicile of origin of that child. Now, legitimation. Legitimation is the legal process of conferring legitimate status to an illegitimate child. So, legitimation is the legal process of conferring legitimate status to an illegitimate child. There are 2 methods of legitimation which are common to most of the legal systems of the world. The first one, legitimation by subsequent marriage of the parents. And the second, legitimation by the recognition given by the child's father. Now, guardianship and custody of minors. When a case connected with guardianship and custody of a minor comes before the English court, the first question to be determined by the English court is whether it is competent to pass an order. The general rule is that the English court is incompetent to pass guardianship or custody orders relating to a minor unless the minor is personally present within its jurisdiction. The English court has jurisdiction to appoint a guardian for a minor if he is present in England, even though he is not domiciled in England. So, the English court has jurisdiction to appoint a guardian for a minor if he is present in England, even though he is not domiciled in England. The English court can exercise jurisdiction also in cases where the minor is a British subject, though not resident in England. Once the court assumes jurisdiction, the court will pass the order of custody after considering the welfare of the minor. So, welfare of the minor is the emphasis here. That is the main criteria for the decision. Whenever the English court has to recognize a foreign court order of guardianship and custody, the court will give much importance to the welfare of the minor. A custody or guardianship order passed by a foreign court or competent jurisdiction will be recognized and given effect unless it is clearly found that it is against the welfare of the child. Now, going to the Indian law, the Indian courts have followed the principle of English law in the exercise of jurisdiction over infants. Once the court assumes jurisdiction, the Indian court will apply Indian law for deciding the question of guardianship and custody of the child. The welfare of the minor will be the first and paramount consideration of the court. Whenever the Indian court has to recognize a foreign custody and guardianship order, the Indian court will consider the jurisdiction of the court, passed the order, and the welfare of the child. So, jurisdiction of the court which passed the order and the welfare of the child. So, we have a case law here, that is Margaret versus Dr. Charco, 1970. So, Dr. Charco, an Indian Christian domiciled in India, went to Germany to study medicine. There he fell in love with and married Margaret, a German domiciled woman. They had 2 children out of this union, a boy and a girl. But their married life ran into heavy weather and finally the marriage was broken down. Both the husband and the wife approached the German court for the custody and guardianship of the children. The German court decreed the custody of the children to the wife with access to the husband once a day every week. Dr. Charco, in violation of the custody order of the German court, took away the children with him and flew to India and went to his native place in Kerala. Margaret came to Cochin and filed a habeas corpus petition in High Court of Kerala. The Kerala High Court held that the order of German court was valid. Now another case law, that is Sarita Sharma versus Sarita Sharma. Here the respondent, that is the husband, was married in 1988. They had a son aged 9 years and a daughter aged 5 years. They, along with the respondent's mother, were staying in USA. There were serious differences between the husband and wife. The respondent, that is the husband, initiated proceedings for dissolution of this marriage in District Court of Tarrant County, Texas, USA in 1995. The associate judge passed an interim order putting the children in the care of the respondent and granted only visitation rights to the appellant. That is, the custody was given to the husband and visitation rights to the mother. In May 1997, the appellant, that is the mother or the wife, picked up the children from the respondent's residence in exercise of her visitation rights, and thereafter she flew away to India along with the children without obtaining an order from the American court. So that happened in May 1997. So the custody was given to the father on 1995, and in June 1997 a divorce decree was passed by the associate judge, and in view of the conduct of the wife, an order was also passed declaring that the sole custody of the children shall be the husband and the wife shall have no visitation rights. The husband then filed a writ petition in Delhi High Court seeking a writ of habeas corpus in respect of the minor children. The High Court allowed the petition and directed the wife to restore the custody of the children to the husband. The passport of the children were also ordered to be handed over to the husband, the father of the children, and it was also directed that it was open to the husband to take children without any hindrance. But the Supreme Court set aside the judgment and order of High Court. Here, the Supreme Court observed that though the decree passed by the American court is relevant factor, it cannot override the consideration of the welfare of the minor children. In USA, the husband is staying along with his mother aged about 80 years. There is no one else in the family. The husband appears to be in the habit of taking excessive alcohol. Though the children have American citizenship, there is a possibility of getting better education in USA. It is doubtful whether the husband will be in a position to take care of the young children. Out of them, one is a female child. She is aged about 5 years. Ordinarily, a female child should be allowed to remain with mother so that she can be properly looked after. It is also not desirable that the 2 children are separated from each other. If a female child has to stay with the mother, it will be the interest of both the children that they both stay with the mother. Here in India, they also get proper care for children is taken, and they are at present studying in good schools. Both children have a desire to stay with the mother. Considering all these aspects relating to the welfare of the children, the court held that the children should be in the custody of the mother in spite of the order passed by the court in USA. So that is with legitimacy and legitimation and guardianship and custody.
So the next topic we have here is immovable property, or what is Mocambic rule and what are its exceptions. Whenever a case connected with property situating in a foreign country comes before the English court, the first question is to be decided by the English court is whether the property under dispute is movable or immovable. In order to determine the question, the English court will accept the classification made by the lex situs, that is, the law of the place where the property is situated. Now, jurisdiction. The English law is very clear that the English court have no jurisdiction to entertain a dispute connected with immovable property situated in a foreign country. So that is with respect to immovable property situated in a foreign country. This rule is known as Mocambic rule. Even though the plaintiff and the defendant are British subjects domiciled in England, the English court will not exercise its jurisdiction with respect to a dispute related to an immovable property situated in a foreign country. So, the case law from which this Mocambic rule was laid down, that is British South Africa Company versus Company de Mocambique. British South Africa Company versus Company de Mocambique, and this is a 1893 case. In this case, the plaintiff company alleged that it was in possession of some land in South Africa. That is, British South Africa Company alleged that it was in possession of some land in South Africa, and Company de Mocambique wrongfully trespassed and took possession of those lands. So, the plaintiff claimed the following three relief. So, here the cause of action was a trespass and the wrongful possession by the defendant. And the plaintiff claimed three relief. The first one, a declaration that it was in lawful possession of the property and they are entitled to recover it from the defendant. The second relief was that an amount of compensation for trespass, and the third relief claimed is an order of injunction restraining the defendant from trespassing into the property. So these were the three relief that was claimed by the plaintiff. Here the plaintiff is the British South Africa Company. Now the House of Lords held that the English court has no jurisdiction to adjudicate upon the rights to possession of foreign immovables, even though the parties are domiciled in England. And this is what is popularly known as Mocambic rule. And the case law is British South Africa Company versus Company de Mocambique. And it is an 1893 case. This general rule of exclusion of foreign immovable property is based upon the practical consideration that only the courts of the lex situs or the situs will be able to make effective orders in respect of landed properties. According to Dicey and Morris, the sovereign of the country where the land is situated has absolute control over the land within his domain. He alone can bestow effective rights over it. His courts alone are, as a rule, entitled to exercise jurisdiction over such land. This is the words and the definition or the statement by Dicey and Morris. Now, there are some exceptions to this rule. So, generally, lex situs is applied when it is related to immovable property, and it was emphasized in British South Africa Company versus Company de Mocambique, that is 1893 case law, and it is also popularly known as the Mocambic rule. Now there are some exceptions to this rule.
There are three exceptions to the rule that the English court has no jurisdiction to entertain a dispute connected with foreign immovables. Now, the first one is actions founded on personal obligation. That is also known as rule in Penn versus Baltimore. So, the first exception is actions founded on personal obligation, also known as rule in Penn versus Baltimore. Now, the second exception is questions affecting the foreign land incidentally arising in an English action. So, the second exception, questions affecting foreign land incidentally arising in an English action. The third exception is admiralty jurisdiction in trespass. So, the third exception is admiralty jurisdiction in trespass. So, the first exception, actions founded on personal obligations, also known as rule in Penn versus Baltimore. If the defendant has undertaken a personal obligation in England, the English court can pass a decree or order even though it will indirectly affect the foreign land. Please note, it's not directly, it's indirectly affect the foreign land. In order to exercise jurisdiction, the defendant should have undertaken a personal obligation to the plaintiff and he should be personally subject to the jurisdiction of the court. If X has entered into an agreement with Y to sell an immovable property in India while they were in England, the English court can exercise jurisdiction and pass a personal decree against X and direct X to transfer the property to Y. Meanwhile, if X fails to act as per the direction of the court will execute its order by imprisoning him in England or attaching his properties in England. Hence, the court act upon the conscience of the defendant. Now, Penn versus Baltimore. So, the actions founded on personal obligation, it is also known as rule in Penn versus Baltimore. Penn versus Baltimore is a 1750 case law. In the old colonial days in America, Penn was the owner of the province of Pennsylvania and Lord Baltimore was the owner of the province of Maryland. So, America Penn was in the old colonial days of America, Penn was the owner of the province of Pennsylvania and Baltimore, Lord Baltimore was the owner of the province of Maryland. These two provinces were neighboring and they entered into a contract in England by which a scheme was devised to settle the boundaries between the two provinces. The defendant, that is Baltimore, the owner of the province of Maryland, the defendant committed a breach of the agreement and the plaintiff files a suit for specific performance of the contract. The court held that it could not pass a decree in rem, but in exercise of its jurisdiction in personam, a decree for specific performance was ordered. So, in this case, the court said that it has no jurisdiction to provide a decree in rem, but it can be passed in personam. So, a judgment in rem cannot be given, but a judgment in personam can be given, and that is affecting Penn as well as Baltimore, because there was an agreement and this is a case of breach of agreement. Penn was the owner of the state of Pennsylvania and Lord Baltimore was the owner of the state of Maryland. Now, the second condition or the second exception, questions affecting foreign land incidentally arising in an English action. In this case of administration of trust, this is a case of administration of trust if the property includes movables in England as well as immovables situated in a foreign country, the English court has jurisdiction to determine questions affecting the foreign immovables for the purpose of administration. So, here the questions affecting foreign land incidentally arising, they are not directly referring but there are immovable properties in England as well as in a foreign country, and they have to decide the administration of the property. So while doing that, when they are making administration for the properties immovables in England, they also make administration for the foreign land property, and this is for the purpose of administration. So it was incidentally arising. In such a case, the English court can take a jurisdiction over it, and we have a case law here, that is re Duke of Wellington. Duke of Wellington case, that is in 1947. So the Penn versus Baltimore case was in 1750, and the Mukambik rule, the Mukambik case was in 1893, and Duke of Wellington case is in 1947. The Duke of Wellington, a British subject domiciled in England, left a will dealing with immovable properties in Spain as well as in England. Now, the English court has decided the question relating to Spanish land also along with the English land. So that is the Duke of Wellington case, that is in 1947, known as re Duke of Wellington. And the third exception here is admiralty jurisdiction in trespass. The High Courts in England can, in the exercise of its admiralty jurisdiction, decide on a question of trespass to foreign land. So, here we have a case law, that is the Tolton case of 1946. The Tolton case of 1946. The plaintiff was the owner and occupier of a wharf in Lagos, that is Nigeria. The wharf was damaged owing to the negligent navigation of the defendant. The plaintiff filed a suit in England claiming compensation for injury caused to the wharf. The court held that the ban imposed by the Mukambik rule is not applicable when the High Court exercises its admiralty jurisdiction. So that was the Tolton case of 1946. So the Mukambik case was in 1893. Then the Penn versus Baltimore case was in 1750. Then we have re Duke of Wellington case in 1946, and the Tolton case is 1940. Sorry, the Duke of Wellington case of 1947 and the Tolton case of 1946. So that is with the jurisdiction. And now the choice of law. All questions in respect of rights over immovable property should be determined by the application of lex situs. So, if it is with respect to immovable property, the applicable law is lex situs, that is the law of the land where the property is situated. Now, Nelson versus Bridport, that is 1864. Nelson versus Bridport 1864. In this case, the court held that the incidence of real estate depend entirely on the law of the country where the estate is situated. The lex situs governs the following issues. So, the lex situs governs 1. Capacity to take immovable property. Then 2. Capacity to transfer immovables by sale, gift, mortgage or in any other form. Then third, formal validity of transfer of immovables. Then that was third. Then fourth, essential validity of transfer of immovables. And the fifth one, succession, both testate and intestate when it is with respect to immovables. So what does lex situs is applicable in which all conditions? We discussed 5 circumstances where lex situs is solely applicable. So the first one is the capacity to take immovables, and the second one is the capacity to transfer immovables by way of sale, gift, mortgage or in any other form. Then we have the formal validity of transfer of immovables and essential validity of transfer of immovables, and then succession of movables as well as immovables. So these 5 circumstances or 5 scenarios or categories are dealt with lex situs, that is the law of the country where the property is situated. Now Bank of Africa versus Cohen. So that is 1909. Bank of Africa versus Cohen, 1909. In this case, the court held that the person's capacity to make a contract with regard to an immovable property is governed by lex situs. So it was reiterated and emphasized that the capacity of a person to make a contract with respect to immovable property is governed by lex situs, and that the case name is Bank of Africa versus Cohen in 1909. That was with immovable property. Now, just like immovable property, we have movable property. Whenever a dispute with regard to transfer of movable property comes before an English court, the first duty of the court is to determine whether the movable property under dispute is tangible property or intangible property. So, when it is respect to movable property, we have to first classify it as whether it is a tangible property or intangible property. So, a tangible property is chosen with respect to possession, and intangible property chooses in action. Now, the law to be applied for determining the dispute with regard to the transfer of tangible movable and intangible movable is different. So what is tangible movable? So a property that can be held, physically held, seen, felt, those are tangible, and those which cannot be perceived by the senses, that is intangible. That is, we cannot feel, smell or taste it, then that is intangible property. So tangible, the law governing the transfer of tangible movables and intangible movables is different. So when we are dealing with movable property, it is very important to classify whether it is a tangible property or an intangible movables. Now the law governing the transfer of tangible movables by act of parties, that is transfer inter vivos, by act of parties, law governing the transfer of tangible movables by act of parties, transfer inter vivos. Inter vivos means transfer inter vivos means transfer between living persons. When a case related to transfer of tangible movable property comes before the English court, it can exercise jurisdiction even though the movable property is not situated in England. So the lex situs rule is not applied here. However, the plaintiff should not be an enemy alien. So the condition here, the plaintiff should not be an enemy alien, and the defendant should be present in England, and a summons should be served upon him. So for the English court to take jurisdiction, the plaintiff should not be an enemy alien, the defendant should be present in England, and a summons should be served upon him. Now, if the court assumes jurisdiction, the next task of the court is to select the law to be applied for determining the validity of transfer. So once the English court assumes that it has jurisdiction, now the next question is, what law should be applied in determining the validity of transfer? There are various theories with regard to the choice of law, and they are the lex domicilia theory and the lex actus theory. Then we have the lex situs theory, the proper law theory. So the lex domicilia theory is the law of the domicile. Then the lex actus theory, then we have the lex situs theory, that is the law of the country where the property movable is situated. Then the proper law, that is which law has the most real and substantial connection. So lex domicilia theory. Now, according to this theory, transfer of movables are governed by law of the owner's domicile. This theory was generally accepted in England and USA in earlier times. But today, that is in the present scenario, it has very few advocates and has been judicially abandoned both in England and USA. So the lex domicile theory with respect to tangible movables has been nearly abandoned by UK as well as USA in the present scenario. Now we have the lex actus theory. According to this theory, the dispute with regard to the transfer of movable property should be governed by the law of the place where it was performed. So, lex actus, where the act took place, law of the land where the act took place, that is governed by the law of the place where it was performed. That is the lex actus theory. And the third is lex situs theory. According to this theory, the validity of transfer of tangible movables and its effect on the proprietary right of the parties are to be governed by the law of the country where the movables is situated at the time of the transfer. So, lex situs means law of the land where the property is situated. So, here it is governed by the law of the country where the movables is situated at the time of the transfer. Now, the last theory with respect to this, that is considering tangible movables. The laws governing tangible movables, under that choice of law, the theories for choice of law, we have 4 theories, and the 4th theory is the proper law theory. According to this theory, the appropriate law to be applied for deciding the question arising out of the transfer of movables is the law of the country with which the elements of the transfer has the most substantial connection. So these are the 4 theories of selection of law or the choice of law under law governing the transfer of tangible movements. The first one, the lex domicile theory. The second, the lex actus theory. Then the third, the lex situs theory. And the fourth is the proper law theory. And now we have modern English law. In a case connected with transfer of tangible movable property, mainly 2 types of question arises. That is, 1. Questions contractual in character. Second, questions proprietary in character. The questions of contractual nature should be determined by the law of the country with which the transfer has the most substantial connection. So, the questions of contractual nature should be determined by the law of the country with which the transfer has the most substantial connection. The questions of the proprietary in character are to be determined by the application of lex situs. So, if you are answering a question of character of the character in nature, contractual in nature, it is the proper law, and if it is with respect to the proprietary nature, it is the lex situs. So, that is with the modern English law. Then we have a case law here. X, that is Camel versus Civil. Camel versus Civil, and that is 1858 case. Here, X, a domiciled Englishman, purchases some timber in Russia, and the sellers ship the timber to X in England by a Russian vessel. So, the man purchased timber in Russia and it was sent to the purchaser in England by a Russian vessel. The ship was wrecked off coast of Norway. At a public auction held at Norway, at the instance of the master of the ship, the timber was sold to Y. By the law of Norway, Y got a valid title to the timber, but not according to the English law. The timber was shipped by Y to England and transferred to the defendant. A suit was brought by X, that is the initial purchaser, in England for the recovery of the timber, on the ground that X continued to be the owner notwithstanding the auction sale in Norway. The defense was that by virtue of the auction sale at Norway, the defendants got title over the timber. The English court held that Y's title conferred by the Norwegian law superseded the earlier title of English purchaser. And here it was because the lex situs at the time of transfer, it was in Norway and the auction took place in Norway. That transfer was valid in Norwegian law. Thus, that title, Y's title conferred by the Norwegian law, superseded the earlier title of the English purchaser. So, this case is Camel versus Sewell in 1858. So what was considered here? The lex situs at the time of transfer was considered. Now, assignment of intangible movables. So, assignment of chooses in action or assignment of debt. Assignment of chooses in action or assignment of debt. Assignment of intangible movables. Chooses in action are intangible movable. They can be divided into two groups. One, those which are mere rights of action, and B, those which are represented by some document or writing that is capable of being negotiated as a separate physical entity. So the first category, those which are mere rights of action. For example, a debt arising from a loan. And now for the second category, that is those which are represented by some document or writing that is capable of being negotiated as a separate physical entity. An example for this is promissory note, bill of exchange, check, shares, etc. Now, assignment of debt. In the case of assignment of an intangible movable like debt involving foreign element, the question would be which law governs the rights and liabilities of the parties. There are various theories, and here the first one is lex domicilia of the creditor, then the lex situs of the debt, then the lex loci actus theory, then the proper law of assignment, then the proper law of debt. So we have 5 theories for the assignment of debt: lex domicilia of the creditor, lex situs of the debt, lex loci actus theory, proper law of the creditor, and the proper law of the debt. Now, lex domicilia of the creditor. According to this theory, the law to be applied for deciding the rights and liabilities of parties to assignment is the law of domicile of the creditor. Now, lex situs of the debt. According to this theory, debt situates in the country where the debtor resides. So, debt situates in the country where the debtor resides. And the law to be applied to determine the rights and liabilities of the parties to the assignment is law of the country where the debtor resides. Now, the third theory is lex loci actus theory. According to this, or lex actus theory, according to this theory, the assignment of debt should be governed by the law of the place where the assignment was made. Now, we have the proper law of the creditor theory. Here, according to this theory, the rights and liabilities of the parties to the assignment should be governed by law of the country with which the assignment is most closely connected. Then the last theory is the proper law of debt. According to this theory, the law to be applied for deciding any dispute arising out of assignment of a debt is a law of the country with which the elements of the original transaction which created debt has more connection. So, the 5 theories under the assignment of debt: lex domicile of the creditor, lex situs of the debt, lex loci actus theory, proper law of the creditor, then the proper law of the debt. The proper law of the debt, according to this theory, the law to be applied for deciding any dispute arising out of an assignment of debt is a law of the country with which the elements of the original transaction which created debt has more connection. Now, modern English law. In a case related to the assignment of a debt, the formal validity and essential validity of the assignment may arise. The essential validity and capacity of parties to the assignment would be decided by the English court by applying the proper law of assignment. Now, so the formal validity of the assignment would be decided by applying the law of the place where the assignment is made, that is lex loci actus. So the essential validity is dependent on the proper law of assignment, and the formal validity is depending on the lex loci actus. The proper law of assignment, According to this theory, the rights and liabilities of the parties to the assignment should be governed by the law of the country with which the assignment is most closely connected. And how is the proper law of assignment and proper law of debt different? In proper law of assignment, we are considering with which country the assignment is most closely connected, and in the proper law of the debt, we are considering the original elements, the elements of the original transaction which created debt, and to which country those elements has the most connection. So that is the difference between proper law of assignment and proper law of debt. Now, Repubblica de Guatemala versus Nunes. That is 1927 case. Repubblica de Guatemala versus Nunes. In 1906, the president of Guatemala deposited a huge sum of money in the London Bank. In 1919, he assigned this sum by a letter written from the Guatemala to his illegitimate minor son Nunes, who was domiciled in Guatemala. He was deposed and imprisoned in 1920. While in prison, he was forced to assign this sum to the Republic of Guatemala. The Republic filed a suit in England claiming the money from the bank and Nunes. The assignment of 1919 was valid under the English law but void under the law of Guatemala. So, we already discussed the formal validity, the Lex Loci Actus governs it. Now, the proper law of assignment in this case was the law of Guatemala, and the court applied the law of Guatemala and held that the assignment in favor of Nunes was invalid. The assignment in favor of Republic was also held to be void for duress. Now, in this case, the English court held that the formal validity of assignment is governed by the law of the place where the assignment was made. So that is with movables. Now, there is succession to movable and immovable property. So the next topic we have here is succession to movable and immovable property. So the first one, intestate succession to immovables. The traditional rule of the English private international law is that when the owner of the immovable property dies intestate, the order of descent or distribution prescribed by the lex situs, that is the law of the place where the property is situated, will be applied by the English court. Now, Section 5 of the Indian Succession Act incorporates this English rule. In India, succession to immovable property in India of a person deceased shall be regulated by the law of India, wherever such person may have had his domicile at the time of his death. So, the traditional rule of English private international law is that when the owner of immovable property dies intestate, the order of descent or distribution of prescribed by the lex situs, and this will be applied by the English court. Section 5 of the Indian Succession Act incorporates this English rule. In India, succession to immovable property in India of a person deceased shall be regulated by the law of India, wherever such person may have had his domicile at the time of his death. Now, Shankaran Govindan versus Lakshmi Bharati, 1964. In the case, the Indian court held that the succession to immovable properties in England will be governed by the English law, and the Indian law will be applied for distributing immovable properties in India. So, Shankaran Govindan versus Lakshmi Bharati, 1964. In this case, the Indian court held that succession to immovable properties in England will be governed by English law, and the Indian law will be applied for distributing immovable properties in India. Now, the second is intestate succession to movable properties. Intestate succession to movables is governed by the law of domicile of the deceased at the time of his death. So, when it was immovables, lex situs was taken irrelevant of the domicile of the deceased at the time of death, But when it is intestate succession of movables, the law of domicile of the deceased at the time of his death is governs the intestate succession of movable property. Now, Section 5 of the Indian Succession Act provides that succession to the movable properties of a deceased person is regulated by the law of the country where he was domiciled at the time of his death. Then the third circumstance is testamentary succession to immovables. The common law rule is that the law to be applied for deciding the validity of wills regarding immovable property is lex situs. The questions such as whether the testator has the capacity to execute the will, whether the appropriate formalities for making the will has been observed, whether the testator has unlimited or only a restricted power of disposition, and whether the interest devised is essentially valid are all decided by the law of the place where the immovables are situated, that is lex situs. The law of domicile of the testator has no rule according to common law in regard to these matters, that is testamentary succession to immovables. The law of domicile of the testator has no role. Now, that was the situation, and then in 1963 the British Parliament enacted the Wills Act and enlarged the rule with regard to the formal validity of wills regarding immovable property. Under the common law, a will which does not satisfy the formalities prescribed under the law of the place where the property is situate is invalid. By virtue of the Wills Act 1963, any will which satisfy formalities prescribed under law of any of the following countries will be declared valid. The first one, the country where the testator was domiciled. Second, the country where the testator was habitually resident. The third, the country where he was a national. Fourth, the country where the will was executed. The fourth, the country where the property situate. So, prior to 1963, by the common law, lex situs was the sole authority that governed the rules with respect to testate succession of immovable properties, and all the formal validity was checked under lex situs. But in 1963, the British Parliament enacted Wills Act, after which there a will can be valid if it is according to the formalities prescribed in either of the five countries, that is a country where the testator was domiciled, the country where the testator was habitually resident, the country where he was a national, or the country where the will was executed, and the country where the property is situate. If the will is valid in either of this country, either of these, then the will is valid. But in earlier case, that is prior to 1963, if the will is not valid by lex situs of the property, the will was invalid. After 1963, after the Wills Act, there was a widened possibility of the will being valid. So, it can be in the form, the formal validity prescribed, it can be in the form either of the domicile or habitual residence, or the nationality, or the country where the will was executed, or the lex situs. So, there was a wider ambit. Now, the fourth one is testamentary succession to movables. The question with regard to the capacity of the testator will be determined by lex domicile of the testator at the time of making the will. Now, the capacity of a legatee to take a bequest under the will is determined either by the law of his domicile or the law of the testator's domicile. It is either one, either by the law of domicile or domicile of the legatee, or the law of domicile of the testator. Now, if there is a conflict between these two laws, the law most favorable to the legatee will be applied. So, the next one is the essential validity or the efficiency of the testamentary disposition is determined by the law of the country where the testator was domiciled at the time of his death. The formal validity of the will shall be decided by applying law of any one of the following. So essential validity depends on the law of the domicile of the testator at the time of his death, and the formal validity any of the following, that is the country where the will was executed or the country where the testator was domiciled either at the time of the execution or at the time of his death. Now, the country where the testator was habitually resident and or at the time of the execution of the will or at the time of his death. The last one, the country in which he was national either at the time of execution or at the time of his death. So, the formal validity is depending upon the any of the following countries. Anyone, if any one of the if the formal validity is complied with in any of these country, that is the four enlistment or the four scenarios are given, conditions are given. The first one, the country where the will was executed, or the second one is the country where the testator was domiciled either at the time of the execution of the will or at the time of his death, and the third one, the country where the testator was habitually resident at the time of execution of the will or at the time of his death, and the fourth one, the country in which he was a national either at the time of execution of a will or at the time of his death. So, if any of the one condition is met, the formal validity will be met. So, that is with testament succession to movables. So, that is with succession to movables and immovables. So, the next topic we have here is recognition of foreign judgments. Foreign judgment means a judgment of foreign court. A foreign court means a court which is established under the authority of a foreign government. In the absence of an interstate agreement, judgments delivered by a court in one country cannot be executed directly in another country. Thus, a judgment given by French court cannot be directly executed in England by an English court unless there is an interstate agreement to that effect. Today, most of the Commonwealth and continental countries, including India and United States of America, give recognition to foreign judgment. Recognition of judgment is different from its enforcement. So, recognition is not equal to enforcement. A court may recognize every foreign judgment it enforces, but it is not necessary to enforce every judgment that it recognizes. So, certain kind of foreign judgments need not be enforced. For example, decree of divorce. They need only to be recognized. In order to enforce a foreign judgment in England, the first step is its recognition by English court. The common law principle is that a foreign judgment cannot be directly enforced in England by direct execution. It is necessary to bring a new action in England on the foreign judgment. After recognizing the foreign judgment, the English court will enforce it. A foreign judgment will be recognized in following conditions, and here we have 5 conditions, and that is exactly the same as the conditions in CPC for recognition of foreign judgment. The first one is the jurisdiction, that the court which made the decree shall have jurisdiction. The second one, it should be a final adjudication. The third one, it should not be obtained by fraud. Then the fourth one, it should not be against the public policy of England, and the fifth one, it should not be contrary to the principles of natural justice. So the first condition, the foreign judgment was of a court which had jurisdiction. If the foreign judgment was of a court without jurisdiction, the English court will not recognize it. And in this context, we have a case law, that is Sardar Gurdyal Singh versus Raja of Faridkot, 1894. The English court held that the court of Faridkot had no jurisdiction against the defendant, since he was not present at the time when the civil proceeding were initiated against him, and the judgment of the court was without jurisdiction and thus not recognizable. That was in the case of Sardar Gurdyal Singh versus Raja of Faridkot in 1894. Then the second condition is the foreign judgment should be final adjudication. If the foreign judgment can be altered in a subsequent proceeding between the same parties, the same cannot be enforced by an action in England. Then the third condition is foreign judgment should not be obtained by fraud. If the foreign judgment was obtained by committing fraud, the English court would not recognize or enforce such judgments. If the foreign judgment was obtained by suppressing certain material facts or alleging certain false facts, the judgment is said to be obtained by fraud, and such judgment should not be recognized in England. Then the fourth condition is that foreign judgment against public policy of England. Foreign judgment which are contrary to the public policy of England will not be recognized by English court. And the fifth one, foreign judgment contrary to the principles of natural justice. So a foreign judgment which is contrary to the principles of natural justice will not be recognized in England. Then we have the Indian law. By virtue of section 13 of the Civil Procedure Code 1908, that is CPC, a foreign judgment is a conclusive and will operate as res judicata between the parties to the proceedings. However, under the following 6 cases, a foreign judgment shall not be conclusive. The first one, foreign judgment not by a competent court, that is without jurisdiction. Then second, foreign judgment not on merit. Third, foreign judgment against international or Indian law. The fourth one, foreign judgment opposed to natural justice. The fifth one, foreign judgment obtained by fraud. And the sixth one, foreign judgment founded on a breach of Indian law. So under these conditions, the foreign judgment will not be recognized in India, and it is given by section 13 of CPC. So foreign judgment not by a competent court. It is a fundamental principle of law that the judgment or order passed by the court which has no jurisdiction is null and void. Thus, a judgment of the foreign court to be conclusive between the parties must be a judgment pronounced by a court of competent jurisdiction. The leading case on this point is Gurudayal Singh versus Raja of Faridkot. In that case, A filed a suit against B in the court of the native state of Faridkot, claiming 60,000 rupees alleged to have been misappropriated by B while he was in A's service at Faridkot. B did not appear at the hearing and an ex parte decree was passed against him. B was a native of another native state, Jind. In 1869, he left Jind and went to Faridkot to take up service under A. But in 1874, he left A's service and returned to Jind. The present suit was filed against him in 1879, that is after he returned to Jind, when he neither resided at Faridkot nor he was domiciled there. On these facts, on general principles of international law, Faridkot had no jurisdiction to entertain a suit against B based on a mere personal claim against him. The decree passed by Faridkot in these circumstances was an absolute nullity. When A sued B in court in British India against B on the judgment of the Faridkot, the suit was dismissed on the ground that Faridkot had no jurisdiction to entertain the suit. The mere fact that the embezzlement took place at Faridkot was not sufficient to give jurisdiction to the Faridkot court, but if B was residing at Faridkot at the date of the suit, it would have had complete jurisdiction to entertain the suit and to pass a decree against him. That is the case of Gurudayal Singh versus Raja of Faridkot.
And then we have foreign judgment not on merits. So in order to operate as res judicata, a foreign judgment must have been made on merits or given on merits of the case. A judgment is said to have been given on merits when, after taking the evidence and after applying the mind regarding the truth or falsity of the plaintiff's case, the judge decides the case one way or the other. So it should be on merits, decided on merits. The third one, foreign judgment against international or Indian law.
A judgment based upon an incorrect view of international law or a refusal to recognize law of India where such law is applicable is not conclusive. Then the fourth one, foreign judgment opposed to natural justice. It is the essence of judgment of a court that it must be obtained after due observance of the judicial process. Now, what is judicial process? That is, the court rendering the judgment must observe the minimum requirements of the natural justice principle. It must be composed of impartial persons, act fairly, without bias, and in good faith. It must give reasonable notice to the parties to the dispute and afford each party adequate opportunity of presenting his case. So those are principles of natural justice. Now, the fifth point is that foreign judgment obtained by fraud is not recognized or accepted. It is a well-established principle of private international law that if a foreign judgment is obtained by fraud, it will not operate as res judicata. In the leading case of Satya versus Teja Singh, a husband obtained a decree of divorce against the wife from American court, alleging that he was domiciled in America. Observing that the husband was not bona fide resident or domicile of America and he played fraud on foreign court, falsely representing to it incorrect jurisdictional fact, the Supreme Court held that the decree was without jurisdiction and nullity. So that was the case of Satya versus Teja Singh. Then in Narasimha Rao versus Venkata Lakshmi, A, who is the husband, obtained a decree of divorce against B, the wife, from American court on the ground that he was resident of America. Then he remarried C. B filed a criminal complaint against A and C for bigamy. A and C filed an application for discharge. Dismissing the application, the Supreme Court held that the decree of dissolution of marriage was without jurisdiction, and in as much as neither the marriage was solemnized nor the parties last resided together in America, it was therefore unenforceable in India. Now the last point is foreign judgment founded on breach of Indian law. So where a foreign judgment is founded on a breach of any law in force in India, it would not be enforced in India. A foreign judgment for gaming debt or on a claim which is barred under the law of limitation in India is not conclusive. Now, presumption as to foreign judgment, that is discussed in section 14 of CPC. Here, it enacts the court that it shall presume upon the production of any document purporting to be certified copy of foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless the contrary appears on the record or is proved. So the presumption is that the foreign judgment is made by a foreign court that has jurisdiction. So if it has to be proved on the contrary, it has to be proved and it has to appear on record. So the presumption by section 14 is that the court has jurisdiction. So that is with the recognition of foreign judgment. Now the next topic is stay of action. Now lis alibi pendens, that is suit pending elsewhere. Lis alibi pendens, that is lis, lis alibi, alibi, and pendens, pendens. Now it is quite possible for the same dispute or cause of action to be litigated in the courts of two or more countries at the same time. For example, a person who has committed a tort in France may be sued in France and England at the same time. In such a situation, the defendant in the English action may raise the plea of lis alibi pendens, that is, suit is pending elsewhere, and claim stay of English action or French action. So either one is stayed till the first action is completed. Now the court has inherent jurisdiction to stay an action in England or to restrain by injunction the institution or continuance of proceeding in a foreign court to prevent simultaneous legal proceedings. So it is to prevent simultaneous legal proceedings in different countries regarding the same cause of action. So it should be simultaneous legal proceeding in two different countries, and it must be regarding the same cause of action. If the plaintiff in England is also the plaintiff in the foreign proceeding, the court may stay the English proceeding or injunct the plaintiff not to proceed with the foreign proceeding. The court can also require the plaintiff to elect between the two proceedings. If the plaintiff disobeys the order to discontinue the foreign proceeding, he can be prosecuted for contempt of court. So that is with lis alibi pendens or the stay of actions. Now, if the plaintiff in the English proceeding is the defendant in the foreign proceeding, or the defendant in the English proceeding is the plaintiff in the foreign proceeding, the court should not grant stay of action unless the foreign action is not merely oppressive or vexatious to the applicant, but also calculated to cause his serious damage. So, when the plaintiff in the English court is the defendant in the foreign court, or vice versa, that is, the defendant in the English court is the plaintiff in the foreign court, in such a situation, the court should not grant the stay of action unless what? The foreign action is not merely oppressive or vexatious to the applicant. So if it's merely oppressive or vexatious to the applicant, but also calculated to cause serious damage, then it can be granted stay of action. Now, forum non-convenience. So we discussed lis alibi pendens, and next forum non-convenience. The English court can stay an action in England even in the absence of the action in a foreign country on the ground that the proper forum in all respect is a foreign country, and the action in England is instituted merely because it was possible to serve a writ on the defendant during a short stay in England. In such a case, the vexation to the defendant is clear. The English action will be stayed if the following conditions are satisfied, that is, forum non-convenience. Now, the first condition, that the continuance of the plaintiff's action work an injustice because it would be oppressive or vexatious to the defendant, or would be an abuse of the process of the court in some other way. So that is the first condition. So if either of the condition is met, it can the English court can stay an action even if there is no other simultaneous legal proceeding in an foreign country. Now, what is the second condition? That the stay of action will not cause an injustice to the plaintiff. So both these conditions should be met. That it should not be injustice to the plaintiff and it shall not be injustice to the defendant. Now, in Maharani of Baroda versus Wildenstein 1972, Maharani of Baroda versus Wildenstein 1972. Here the plaintiff, that is a Maharani, and the defendant was a famous art dealer, that is Wildenstein. Both lived in France. The Maharani purchased a painting from the defendant in Paris. The painting was sold to the Maharani as the work of a reputed painter, but that was not the work of the that reputed painter. The actual cost of the painting was less than the cost paid by the Maharani. Maharani sued the defendant in England for breach of contract, and the writ was served on the defendant while he was on a short visit to England. The defendant moved for a stay of action on the ground that the proper forum to decide the case was France. But the English court has not stayed the action because the defendant could not satisfy the court that the stay of action will not cause injustice to the plaintiff, that is the Maharani, and the continuance of the action will result in injustice to the defendant. So there was no stay of action given. So that is with the stay of actions, and that is with the full series of private international law. So thank you for listening. I hope this is helpful for all. Now, if you have any comments or feedbacks, please drop it in the comment box. Now subscribe. It will be very helpful for me if you subscribe. And then don't forget to click that bell icon so that you get an update when I upload my next video or a podcast. So if you have any feedback, anything that you want to tell me, please drop it in the comment box. Thank you once again.